Yes.
They is not available. They may be taken up some other day.
Acha, Mr. Chaudhary has some problem. Okay. You're Mr. T. Kashyap, learned advocate appearing for the petitioner, submits that um, that the matter may be taken up on a later date. Prayer is allowed. List this matter on
Sometime next week.
sometime in the next week.
Next week, second or third week of June.
Okay. List this matter on 11th of June. Okay.
Much older.
May I please, Your Lordship? With the consent of other side, Lordship, I beg to mention item number 52.
52.
Some accommodation for today. Next week, I have taken the consent.
Wait. 52.
11th or 16th.
Yes. 2020 matter.
Lordship, for the
Okay.
week, only for 1 week.
Mr. S.S. Roy, learned CGC, makes a prayer for adjournment, which is allowed. List this matter accordingly on
11th or 16th.
on 16th of June.
Mayor, please, your lordship, I would like to consent of the other side. I would like to mention item number 5.
5. Yes, 523 matter, yes. When do you want?
17, lordship.
Okay, Miss
And be Kaistha.
N.B. Kayasta. N.B. Kayasta, learned counsel for the petitioner, submits that adjournment will be granted in the instant matter. The same is allowed. List this matter on which date you said?
17.
17th of June. It's a Wednesday.
May I please, lordship? With the consent of the other side, lordship, I beg to mention item number 12 to 40, lordship, series matter. In this,
12 to 40.
yes, lordship, in this matter, Deputy SJ Arkadev Chaudhary will appear. And today he is out of station, lordship. So kindly fix some another date,
My lord,
lordship.
on the next date, my lord, Tuesday, my lord, next Tuesday.
After
Next
9
Tuesday.
After 9 June.
After
lordship.
9th. Okay,
That-
16th?
11, my lord.
11.
Lord.
11.
Hearing-
11 there are matters.
11 is the Wednesday.
Hearing date.
It's a Thursday.
Yes.
16 will do.
Yes.
Tuesday?
lordship. Yes, lordship.
Lord.
Okay. Okay. Miss Borua, S. Borua,
Yes, lordship.
learned counsel for learned CGC.
Yeah.
CGC submits that the conducting counsel has some personal difficulty and has prayed for adjournment. Prayer is allowed. List this matter on 16th of June.
My lord, there is an
Okay.
interim order, my lord.
Interim order passed earlier shall continue until the next returnable date.
Same
Right.
prayer for item number 51, lordship.
51.
Yes, lordship. Here also.
So
Deputy
Mr.
SJ
R.K.D. Chaudhary will
Yes.
do.
Yes, lordship.
Yes. 51, you write that Miss Borua, learned CGC, makes a prayer that Mr. R.K.D. Chaudhary has some personal difficulty in doing the matter today and as such has prayed for some time. Prayer is allowed. List this matter on.
After 10 16 or
List this matter on 18th of June.
yes, lordship.
I beg to mention item number 50, Your Lordship.
50.
Yes, Your Lordship.
Yes.
Mr. H. might have some personal difficulty.
2018 matter. Let it reach. I'll see.
The senior is not present, Your Lordship. Mr. Hasibur Rahman. He has some
Yes.
personal difficulty.
But then see, 2020 matter. This is 18 matter.
Sure.
Now, so many years,
One
6 years
second,
have elapsed. What 6 years? 8 years. This is the last chance, okay? I'll give you a short date, you do it. Mr.
PJ Das.
P.J. Das, learned counsel for the petitioner, submits that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter on. This is what? It has come up for hearing. We'll list this matter on 18th of June or 11th of June. 11th of June.
Wait, please, Your Lordship. Lordship, I beg to mention item number 6, Lordship.
Yes.
We have to file affidavit in reply. Kindly give us a small date, Lordship.
Mr.
U.S. Bora.
U.S. Bora,
U.S.
learned
Bora.
counsel for the petitioner, submits that he requires some time to file the affidavit in reply. Prayer is allowed. List this
In
matter
accord-
when?
On 16th of June,
List this matter on 16th of June.
Lordship.
Preparing for the respondents.
Achha. Miss M. Bhattacharya is for the respondent. Huh? And what? Additional senior government advocate.
May it please the lordship.
Lordship.
He's filing his reply against your affidavit, I think. Then, yes.
May it please the lordship. The lordship with regards to item number 58,
Hmm.
May I pray for upgradation to be taken up at 2? Because the petitioner is retiring in the month of November.
Ah.
So if suppose, because the matter relates to downgrading in the APAR, ACR.
Hmm.
And if suppose, otherwise there is a settled case law, Your Lordship, there are many case laws in this.
Matter is ready. It can be taken up for disposal.
Yes, sir.
This is hearing.
Readings are complete. Yes, Your Lordship.
Are you are for petitioner
Yes, Your Lordship.
or D. Bora?
Yes,
Okay. We'll take it up at 2.
highly obliged.
Hey, please, Your Lordship. Lordship, with the concern from the other side, I beg to mention item 47, Lordship.
47.
Lordship, yes. Lordship, the arguing counsel is not well, so Lordship may kindly adjourn. the matter for-
2016.
Yes, Lordship.
Older than the earlier one.
Lordship.
Who is your arguing counsel?
H.
H.
Chakrabarti-
Hetri.
oh, H. Chakrabarti. MP Sharma, Lordship.
Hmm?
MP Sharma.
MP Sharma. This is the last chance, okay? I'll give you only a week's time. Miss
HK Sumi.
H.K. Sui, learned counsel for the petitioner, submits that the conducting counsel has personal difficulty in doing the matter today and has prayed for some time. However, it is seen that the matter relates to the year 2016, and as such, only a week's time is given. Accordingly, list this matter on 11th of June.
Lordship, can it be on 18/11? We had
List
some
this matter
difficulty.
on 18th of June, on which date the matter will be taken up for disposal.
Obliged, Lordship.
Hmm.
In this case, my lord, we could not contact the petitioner, my lord, for last week,
Hmm.
my lord. And whether anything survived in this petition, my lord, that is also,
Hmm.
so my lord, one further week time may be granted to us so that in the meantime, we may contact the petitioner, my lord. We are in difficulty, my lord, without his.
Mr. A.H.M.R. Chaudhary, a learned counsel for the petitioner, submits that he has no contact with the petitioner and as such prays for a week's time to do the necessary exercise in getting in touch with the client. Prayer is allowed. List this matter on 15th of June.
Obliged.
Ah.
In this case, my lord, petitioner before your lordship, give them, my lord,
Last time, Miss R. Kotoki took
Yes,
time on behalf of M.
on behalf of
Kotoki.
me, Lord.
Achha. So what happened? You are having spondylitis problem?
Yes, cervical spondylitis, it's severe something.
Cervical spondylitis.
Please some trip joining here.
Oh, take care. I think you have to do some exercises.
Physiotherapy is going on.
Physiotherapy is doing. It will get better. It's okay. Yes. You are ready with the matter?
Not really, Lordship, because this matter is handed over today morning, Lordship. I have not the brief. I am taking the second copy here, Lordship.
Hmm.
Lordship, so far they have given me verbal instruction that he is not completed 1 year service in the department, Lordship.
He has not completed 1 year
Completed
service
1 year
also.
Service in the, before 1 year service, he died, Lordship. So as per the OM of 2017, he is not entitled for any family.
Entitled for what?
Compassionate family pension.
Oh.
As per the OM of 2017.
So he has not completed 1 year in particular department.
Department, Lordship. Before completing 1 year, he died, Lordship.
But then he has otherwise completed his tenure.
No.
my lord,
Can it be taken up today or you want to go through the matter?
Want to go through the matter, 1 week time, Lordship.
Okay, let her go through. She is also not well. Okay.
আপনারা, my lord, better of 2021, my lord, relief pension, my lord.
Only
Friday.
1 week, Lordship.
Only 1 week.
Friday
this-
may be taken.
Friday. Okay. You go through. You are
Friday.
Miss M. Kotoki, right?
Kotoki.
Yes, heard Miss M. Kotoki, learned counsel for animal husbandry and veterinary department, seek some accommodation on the ground that she has to go through the case. Prayer is allowed. List this matter on Friday, right? 5th of June. Go through. Slow.
Obliged.
Okay.
Here for 2 and 3.
Uh-huh.
appear for two.
Oh, Mr. D. Bora, learned counsel, appears for respond number 2 and 3. उसको पहले लिख लेना. Yes. A.K. Ghosh, learned counsel, appearing for us, prays 3 weeks' time to file affidavit and also to reconstruct his brief. He lost his brief.
Affidavit till yet, Lordship.
Huh?
Last chance may be given, Lordship. With Hannah.
Still, you are not ready. Additional affidavit by petitioners. You have not filed, right?
No, Lordship.
So prior to this order, lordship, previous order was denied or clear for regularization. At this stage, lordship, definitely we entitled to get regularization. And because lordship recent judgment of this honorable Supreme Court lordship, holding stated and was the offender's judgment lordship. So
Offenders, we
petitioner
know.
has been- Yes, petitioner has been appointed prior 1/4/1993 as per the office memorandum dated cabinet decision dated 11th of May 2020, 1995.
These teachers.
No, lordship. Master worker and the casual worker lordship, working under
Mm.
Town Panchayat lordship. Defined.
Okay, let them file affidavit, right? And her senior is also not there. So you miss
P. Thapa, Lordship.
P. Thapa. Miss P. Thapa, learned counsel, appearing on behalf of
S. Datta.
as doctor, prays for a week's time to file the affidavit, prays for a week further time. No, prays for a further time of a week, 1 week. Prayer is allowed to file the affidavit in opposition. Prayer is allowed. List this matter on 10th of June. Please file it before that.
Lordship.
Okay. No further time, huh?
Lordship. Deeply.
10th of June. Yes, Mr. Pathak, Khadi Board,
My lord.
Retired Employees Association, what has happened with them?
So petitioners are claiming for payment of regular pension in terms of the Assam Service Pension Rules. There was a previous round,
1959.
yes, there was a previous round of litigation where a mandamus was passed directing the authorities to consider the prayer of the petitioners in terms of certain parameters. Thereafter, a contempt petition was filed, and an order was passed. The primary grievance is once a mandamus is
What happened to the contempt?
contempt was closed because an order was passed by them, Your Lordship. The primary grievance now, Your Lordship, the primary issue is once a mandamus has been issued to dispose of the matter while considering certain parameters, they may consider other issues, but those parameters which have been laid down by the court have to be considered.
Those were not.
Those were not considered.
I have seen in other cases also. They go in a different direction.
Yes.
So, be ready?
No, ma'am, your ladyship, Mr. R. Babuja is leading the case. He's on legs in court 1 year, lordship. We take it after some time, your lordship.
Okay, after some time. Can it be taken up for disposal today?
Finance has not yet filed their affidavit in my notes. So.
Yeah,
handloom
Mr. Munir,
department-
you are for? Respond number 4 and 5. Mr. Munir. 4 and 5. Okay. So, finance has to file their affidavit required.
Because the handloom department has filed an affidavit more or less reiterating whatever has been stated in the order.
Uh-huh.
But it appears that order was passed pursuant to a joint meeting. The meeting, minutes of the meeting is on record
Hmm.
between the finance department and the handloom department. Your
Hmm.
Lordship. So their contention is that the board, the employees do not qualify as state government employees.
Acha.
So therefore, they are not entitled to pension.
Oh.
So my stand is it being a statutory body and completely dependent upon finances of the government,
Hmm.
they would definitely qualify as employees of the state government.
Has already been decided by this court.
Yes, the court had decided only reason because it is in the realm of policy. It
Huh.
is only on that ground that the matter was remanded back to the authorities to take a consideration upon certain parameters.
Hmm. Okay, finance, who is appearing? Finance.
Mr. R. Pujari, your lordship.
Uh-huh.
R. Pujari. your
R.
lordship.
Bor Pujari.
Yes, your lordship.
So you are praying on his behalf.
Yes, your lordship.
He is in legs.
Yes, your lordship.
But then finance he is appearing.
Yes, your lordship.
But no affidavit.
No, not yet, your lordship.
So affidavit is required, I'm told what? It
Yes,
is
your lordship.
required.
Yes, your lordship, it is required.
So let them take a week's time. I'll give it to you.
Yes, other-
File your affidavit. Other affidavits are on both.
Otherwise, the handloom department has filed their affidavit.
Hmm.
We have filed a reply.
Acha. So Miss, your Miss
R.M. Borwa, your lordship.
R.M. Borua, Learned Counsel, uh, appearing on behalf of Mr. R. Bor Pujari, submits that the the finance department is required to file an affidavit and be given some time to do the same. Prayer is allowed. List this matter on 12th of June, next week, Friday, 12th of June 2026, by which date?
We have
The
16th, Your Lordship.
okay, 16th of June, Mr. Pathak.
My lords.
Miss 16th of June, by which date the learned counsel for the finance department would file their affidavit.
And we may be granted liberty to file a reply.
Okay. And the petitioner is given the liberty to file reply, if any. Jaya Bhavyanai. Yes, Mr. Jaya Bhavya will come.
Yes, madam.
Okay. After some time.
I am appearing in item number 8.
Mm.
Now, my lord,
You are in 9.
my learned friend is for 9.
Mm.
Now, the issues, my lord, involved in both the cases are distinct in nature.
Okay.
Even the prayers are distinct and the grounds undertaken are also distinct, my
So
lord.
how come it is stacked
It has
together?
been wrongly listed, my lord. There's an order which has been wrongly made, my lord. So, my prayer would be to, my lord, detect the matters and the matters can be heard individually, my lord. The challenge and the prayers and everything is
It's okay. If it can be heard today, we can hear both the matters.
He wants to argue item number 9, my lord. He can argue item number 9. 8 may be delinked, and I'll argue item 8 and some other day, my lord.
Achha. Where is the tagging order?
My lord, there's an order dated 28/1/2026, my lord.
Appointed as against the same advertisement.
Register to list this matter again for further hearing. No. Where?
There's an order dated
26, 28, 1.
in item number 8, my lord. I think there's an order dated 28/1/2026.
28, 1, there is.
Item number 9, my lord.
Achha, achha, achha.
In item number 9, the order. Initial text are in,
But
saying
subsequent prayers and grounds are different.
27, 1, 26. Or what?
I think there's an order dated, my lord, 28/1/2026. There must be some order, my lord. In item number 9.
There is no order.
There was the order in item number 9.
9 only I'm seeing. 4540.
Four or 5 dates, I guess. Dates that I don't remember. I will check on the.
We'll check the date and my lord.
Okay, we will hear item 9 then.
My lord. Item 8, my lord, may fix it some other day.
Achha.
I'll-
You are Mr. A.K. Borua.
Okay, bro. Any
Mr.
hearing day, my lord.
Mr. A.K. Borua, learned counsel for the petitioner.
In item 8.
In item 8, for the petitioner, submits that both the matters which are tagged together, no, not both, submits that the writ petition being WPC number 4540 of 23, which is tagged along with the instant matter, is different. And as such, he has prayed that the said matters be detagged and heard separately. He as such prays that the instant matter may be heard on a later date. Prayer is allowed. List this matter on
Hearing day.
on 16th of June.
16. 6. Obligation.
Number 9, you say 4540, right?
Okay.
I will continue.
Whether pleadings are complete? I don't see any affidavits here.
Actually, this is the fourth litigation. So earlier affidavits were filed by that party.
Those will cover the issue.
Yes.
But who appears for the respondents? Miss Mushahari?
Secondary education, I think.
D. Mushahari was there on the last occasion.
Yeah, secondary education.
Lordship, after some time, I will call somebody from the second.
Yes, for secondary education.
Lordship, I will call.
Call her. If she is ready only, we can take it up. Otherwise, we'll have to get deferred. So call her. She was here, perhaps. I've seen her.
Whose name is there recorded?
On the last occasion, no name is reflected. But
I will call someone from.
aberration, but on the occasion before the last occasion, she was there. And she had prayed some time to get the instructions. I'll just read the last order, wait. No, last time, Mr. Where did he go? R. Borua was there. Miss R. Borua, Department of School Education. Okay, I'll take it up after some time. Huh? You inform Miss R. Borua or D. Mushahari? Allah Pisatla.
Lordship, here in this matter, Lordship, the college authority has submitted a LEB proposal in respect of the petitioner.
What proposal?
LEB, it says LEB. So, Lordship, there's
Leave encashment benefit.
Oh,
leave encashment benefit proposal, Lordship. So, Lordship, I've just received their communication. So, the department is seeking for 10 days further time to give me something in response. Lordship,
Mr.
because
Roy,
they have
what do you
just-
say?
They have furnished
I have no. If they-
Acha, acha. Yeah, Mr. Roy, you are for appearing for?
college. The principal.
Phone number 4 to 10.
Acha, acha. So, Mr. Purkaster, they want some time to get the complete instructions.
The college has furnished us, so the department.
Huh?
Have we given the copy of the proposal, madam?
It has been done by the college to the department. Copy to লাগে আপোনালোকে যোনটো আমাক দিছে
No, that is for the government. We're sitting the government.
Okay, Mr. Upamanyu, learned D. Upamanyu, learned Standing Council for Higher Education Department, seek some further time to get the complete instructions. Prayer is allowed. And the same is not objected to by learned counsel for the petitioner as well as other respondents. List this matter on when? 18th of June,
Lordship, can it be on 22nd, Lordship?
22nd of June,
Yes, Lordship.
last week.
Yes, Lordship.
Okay, 22nd of June.
Highly obliged, Lordship.
Yes, Mr. Barmia, you were not there. The matter was called. It's okay. What is your, which item is your matter?
My item is 7, my lord.
Okay.
Yeah, my lord, what happened, my lord?
Hmm.
In persons to the order of the honorable court, my lord, ELC has recommended my name, my lord. That is the BTC.
For provincialization?
No, my lord, compassionate appointment.
Acha.
Then SLC, my lord, did not consider.
Why?
They said, my lord, in order
3 years.
They
Not
said-
3 years.
more than 3 years, my lord. They said.
No, there was a bar, no, that you
It
have
is
to
a
have.
part- It is the negligent part on them, my lord, because I have to approach 3 times to the honorable. Ultimately, my lord, ultimately, by virtue of the order of the honorable court, my lord, they have conducted the DLC, my lord. Operative part, lordship will see page 40, my lord. That's the last
40.
40. Then my operative.
This is the court's order.
Yes, my lord, court order. Accordingly, this court is of the view that interest of justice will be served if the present petition is closed with the direction to the respondent authority, more particularly to DLC to consider the case of the petitioner in terms of office memorandum so and so, pass appropriate orders thereon. Exercise shall be carried out within a period of 45 days from the receipt of the certified copy of the order. Thereafter, authority will intimate the decision.
Acha, what is this OM?
OM, my lord, I have annexed, my lord. That I'm coming, my lord. Then, my lord, lordship will see page 42. DLC, BTC, and during that time, my lord, several years, my lord, BTC was not having DLC, my lord.
So
Then, my lord-
this DLC had recommended you?
Yes, yes, yes. Page 47, my lord. At 47, third paragraph, my lord. At present, due to the availability of the vacancy, DLC meeting held of the BTC recommended the application of Bijoy Deka, son of so and so, for SLC Assam through Welfare Board
department, Dispur got a for appointment on compassionate ground against the sanction vacant post. Post is there, my lord.
Then,
Thereafter, my lord, SLC and prior to that, my lord, prior to date, my lord, the authority has made several queries, my lord, page 55, my lord. With reference to the subject, I have the honor to furnish the supporting documents, applications duly recommended by the
this is by director,
director.
to the
Director
secretary.
BTC, my lord. Next page also,
Wait, I have not finished reading. I have the honor to furnish you supporting.
my lord,
And
they
David
ask for
Lepper,
death
Lepper,
certificate,
Lepper,
legal here, NOC from other
Lepper,
siblings, education, qualification, vacancy position. Next page, my lord, 56.
Hmm.
They also asked, my lord, some queries, my lord. It has been 3 numbers of queries has been raised.
Hmm.
5 of total for post appointed compassionate ground for grade 3 and 4, a total man in position under compassionate ground. How much monthly family pension has been laid down in family members of the working other sensitive so and so.
Hmm.
Thereafter, my lord, page 57.
Hmm.
All the necessary documents have been given by the by the BTC to the DLC, my lord.
Hmm.
All relevant document, my lord.
Mm.
SLC is the impugned, my lord. That your lordship will see page 63, serial number 5,
63.
my lord.
Hmm.
Operative part of the SLC.
Hmm.
Page 63, serial number 5.
Hmm.
Bijoy Deka, son of so and so.
Serial number 5.
5, man. I'm Bijoy Deka.
Ah, yes.
Vijay Deka, education qualification, date of birth, date of application is the right time, my lord.
Hmm.
Lordship, kindly note down the date of application 18/1/02.
Hmm.
Date of DLC meeting 209/23.
After so many years.
Yes, my lord. I have fighting, my lord.
Hmm.
Then service book left, service 3 years, 10 months. That also I am covered, my lord.
Hmm.
Then lordship will see decision of the DLC which is impugned. The SLC went through the order passed by the honorable court and wherein DSL has directed to consider the case of the appointment of the compassionate ground in terms of so and so.
Hmm.
The DLC in its meeting held on 29/23 recommend the application of Vijay Deka to be placed before SLC. SLC noted the government employee expired on 2001, more than 23 years ago. The object of the compassionate appointment to provide the bereaved family with immediate financial assistance to cope up with the situation and accepted norm, and the several years have been lapsed on the death of the government employee. It would be appear on the face of the family has managed to support his all. The so ordinarily to be given in the instant case, SLC has not recorded any ground. Recommendation in particular has not made out the case to justify the appointment of the compassionate appointment after 23 years of government employee in the light of above SLC rejected.
But then he made his application immediately after the death.
Everything in time, my lord. 3 times writ petition.
When did your father die?
My father
It
died.
is somewhere reflected.
Yes.
Oh, yes.
I have
So
annexed
the date of the deceased was in 2001.
one.
And he made the application in 2002.
I have already.
But the recommendation was very late.
Yes.
DLC meeting was in 2023. So it is not his fault. Only ground taken that over these years he had survived.
My lord, that
Family had survived.
That-
So it's not required.
that cannot.
Then this is what you have impugned.
My lord, only impugn is that, my lord. SLC, if it gave that. Along with me, my lord, some other persons also appointed, my lord. I do not have the name, my lord. Those who has applied.
You know, in this matter, Miss M. Bhattacharjee, she is appearing in this matter. Maybe she has some instructions, so it may be fixed in some time.
Okay, after some time then.
Sometime.
Okay. Otherwise, the rejection of by the SLC doesn't seem to be good.
Yes, ma'am.
You have some replies?
We have nothing to say, Lordship.
Ms. Bhattacharjee will say.
I'm for BTC, we are for DLC.
BTC recommended, my
We
lord.
are recommended.
And
They are
during that
rejected
time,
by
my
the
lord,
SLSC. SLSC by the
The
government.
SLC, the BTC, why?
SLC.
BTC has no role now. SLC is of another.
no, my lord, first DLC.
Ah.
DLC will recommend to the SLC. SLC will act upon that. But
Then
that
they
has-
will send it to the government.
Government
Yes.
lordship.
Okay, let Ms. Bhattacharjee come. After some time, Mr. Barbhia.
My lord.
Has the affidavit been filed? No.
No, no.
Okay, the instructions will do. Affidavit is not required. Okay, let her come. Okay. Affidavit may not be required. Her
May not be
instruction will do.
Notification reflects, my lord, I have annexed most probably, my lord. Notification, there is a quite exemption for PTC, my lord, state schedule area.
No, let her come. She was here. Okay, we will see the instructions.
Okay, man.
This is a very small matter. Why no affidavits are not required. Right. SLC had rejected it on some flimsy grounds. We'll see. Let her come. If you have some, Mr. Barbhia, if you have some other matter, do and come back. You too?
41.
Yes, 41. 41? Oh, supply.
File our affidavit
Oh,
in this
acha,
manner,
acha.
ma'am.
Just a second, Mr. Talukdar. Oh, that series left went, no? Acha, wait. 41. Yes, 41. Mr. P.K. Roy Chaudhary is there. Today he is not there. What happened? 41. No further adjournment. Instructions were received by Mr. Fukon. Right. Okay, let Mr. P.K. Roy
We have
Chaudhary.
already filed affidavit.
You have filed your affidavit.
Ma'am.
Maybe Mr. Roy Chaudhary thought that the matter will reach late, so he has not come. We'll take it up some after some time.
42.
Ma'am,
Hmm.
in this case, my lord, the petitioner has challenged the or impugn order,
Hmm.
page 42, ma'am.
What about the other party? No one is here.
Secondary education department, madam. With regard to.
Secondary education, who appears? Mr. Sharma, you are for elementary. Mr. Bhuya, you are for secondary. Higher education. Secondary Ms. D. Mushahari is there. Inspector of Schools also is there.
Is allowed to hold.
And
the-
NCTE, National Council. Ms. Terangpi, are you there for secondary education?
In this case, whatever, my lord, the petitioner has been rejected on the ground that he procured the higher education, my lord, without taking the NOC from the
Oh.
department. This is the ground.
During his service career.
Yes, sir. He has obtained the B.Ed degree and master degree, my lord, from the
So he had procured those degrees without NOC.
without NOC.
So any case have any settled position? Any case
Yes,
has
yes,
been
even the judgment, my lord, in excerpt 8, page 34.
page 34.
Yes, sir. Similar,
What paragraph?
paragraph, my lord,
What does the judgment
paragraph
say?
13, my lord, page 41.
41.
Eh.
Disposed of directing the director, secondary will consider a claim as well as other candidates who are eligible for consideration of in charge principal.
Oh, sorry, sir.
For in charge principal
Hmm.
of so and so and to take necessary steps for filling up the said post in accordance with law. Consider the claim of the petitioner. You also want a consideration order?
Yes, I may be given the charge of the principal.
In charge, the requirements for in charge principal and principals are same, right?
Same.
Under the act?
Yes. Under the rules 2018. Under
2000,
12,
yes. Under Rule 12, section 12.
2018 rule. And I duly fulfill this all this criteria, my lord. And as such, presently I'm as per.
You are the head teacher or what?
I'm the academic in charge of the school, my lord. Inspector of schools has given me to look after the academic charge of the school, my lord. Page 25, Annex 3 is the, my lord, the statement submitted by the,
You are Nilutpal Goswami.
yes, Lordship.
Then what happened? This is the dice data or what?
No, this is not the dice data, this is the, my lord, statement for giving the charge.
Acha, in charge
Order.
principle.
Yes, yes. Yeah, in the
It is-
remarks column, you will find 17, column 17.
Hmm?
In column 17, my lord.
18 is remark, 17?
17, it is written that I was
Yes,
Hmm.
not what is this?
whether be it
Yes.
acquired while in service
Yes.
service period, yes.
Hmm.
Whether no on deputation or not.
No.
Permission to undergo B.Ed such and such memo number?
No, whether on deputation or not, no.
No.
3 is if not on deputation, whether
Permission
previous
does-
permission, NOC was obtained. Permission to undergo B.Ed, a memo so-and-so dated demand. Permission to undergo was there,
Yes.
but the
And again,
previous NOC was not there.
yes, Lordship. Again, in the paragraph column 13, Lordship will find.
Hmm. If educational qualification acquired in service period, please state whether previous permission not.
Not.
So that previous permission was not taken.
Not taken.
In the case that you have placed, there also no NOC,
Yes.
but then consideration order was passed.
Yes.
Yes, Ms. Terangpi, of course, an NOC was not there.
There, yes, Lordship. I
So
need to
you
obtain my
consider
instructions,
still-
Your Lordship.
And what? He had said that he had informed you
Yeah.
about his decision to get the degree, only that permission was not there. So you can still consider.
Lordship, on the next day, Your Lordship, let me obtain my instructions, Your Lordship.
There is nothing to obtain instruction. You just have to.
Already admitted text.
Only that you have to consider, you have to tell the authorities to consider to the post of in charge principal,
That is true, Your Lordship.
like in the order. Okay. Heard Mr. B. Purkasta, learned counsel for the petitioner, and Miss H. Terangpi, learned standing counsel for secondary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction to the authorities to consider where is your prayer? Wait. To the oh,
It's
acha,
7.
so where is the show cause notice was issued? Huh? Show cause notice was issued to you.
Of course, notice.
On what charge? Only on this,
On
NOC.
the Annex 9, my lord. This is the-
Absence of NOC.
Yes.
Which page?
Annex 9, my lord.
Page 42, Your
Page
Lordship.
Acha. No, notice. Let's come to the notice. You perused the B.Ed part-time course as a regular student during period so and so. 30, no government service.
They asked the question, my lord, how did you attend regular classes for
Mhm.
B.Ed course without hampering your teaching duties at the such and such school? Whether your regular attendance and duties such and such. It answer is that, my lord, it's a annexer 5.
So you have submitted your written reply.
Yeah, the written reply as well as, my lord, I have annexed the annexer 6, page 30. This is the NOC, NCT recognition to that degree, part-time degree, my lord, B.Ed degree.
Where is that page?
Page 30. This is the recognition order of the degree.
Recognition order by NCT.
NCT.
Submitted application to the Western Region Committee of NCE for grant of permission to so-and-so run by so-and-so for B.Ed course.
Yes. Third paragraph will also find part-time course. 3 years. Only the examination is required to go, my lord.
No, this is for the recognition order of the university.
Yes, they have that recognition order indicates, my lord, it's a part-time course. It's not a regular course to be attended by disturbing my classes.
Where is that?
Paragraph 3, my lord.
Whereas the institution Swami Vivekananda University run by so-and-so, plot number so-and-so, Madhya Pradesh,
Yes, yes.
part-time.
Part-time. Only for examination I had to go.
Where is your reply to the show
Reply-
cause?
Reply, I have not sent. Reply, that is only given, my lord, reply. That reply I have given by, that copy is not kept, my lord.
You should have annexed the reply copy.
Reply copy was not, I asked him, my lord, it was not available because he did not keep for one copy for him while submitting the.
He did not keep any copy.
He did not keep. He submitted for the IS.
But then the fact remains there was a show cause notice, right?
Yes, Shokos. I put to challenge this Shokos notice also. This honorable court has given direction, my lord, for such types of cases. Shokos notice can be maintained, my lord. Yes, quashed in the case of Tonkeshwarnath case, my lord, it is also quashed.
Where? Show me those.
Yes, I will give them.
You have not brought today.
It's there, I'll give for you.
Lordship, can it be on the next day? Let him also produce the, in the meantime, I will also obtain my instructions, Your Lordship. Since he doesn't have the so forth.
Okay, you bring those judgments where show cause notices cannot be issued, they said.
Yes, Tonkeshwarnath case, I'm giving the number, my lord.
Okay, you bring it, we'll hear it day after tomorrow. Okay, you also bring the instructions. Mr. On the prayer made by the learned counsel for the petitioner, list this matter on 4th of November, 4th of June. Your day? NCT.
NCT.
So what do you say on this? He has not obtained NOC before, while appearing in the examination of B.Ed during his service tenure.
NCT is to say, my lord, whether my degree is a valid degree from that university. That is, they have to affirm.
Okay, you bring the decision where show cause notices cannot be a part of.
Yes.
Let's this matter, huh?
Item 9, I'm doing 9.
Lordship, in item number 9, I need to obtain my instruction from the IS, Your Lordship.
Inspector of schools.
Yes, Your Lordship.
This is a fourth
Mm.
times litigation, and earlier.
See, on the last occasion, R. Borua, Learned Standing Council, School Education Submit, the respondents have instructed that Subodh Kolita is continuing as an assistant. There were instructions
Yes, Your
already.
Lordship, but we have sent already a communication letter from the director office to the IS, Your Lordship. So I need to obtain the instructions from the IS, Your Lordship.
My lord, the Subodh Kolita is the item number 8. So his part and his claim.
Subodh Kolita is item number 8.
Yes,
But there is a reference to Subodh Kolita here.
that is correct, my lord, because earlier initial things at the year 1998 against the appointment of a advertisement is same. Both party applied. Subodh Kolita, that person was appointed as LDA, whereas I was at the serial number 1 because at that time that select list was not published. Thereafter, that person was upgraded to assistant teacher. So the
Subodh
LDA
Kolita.
Yes.
Mm.
And LDA post is still lying vacant. I am fighting this person. Is fighting since 1998, man. 4 or 5 cases has been filed. Clear directions in 3 cases were there to the secondary director, but the director had not made any decision. Therefore, on the last order, my lord, in the writ petition filed by this person, 1,50,000 was fined, my lord, against the director and the commissioner.
So what do you have? You know this matter? Have you gone through?
No, Lordship, the earlier matter I haven't gone through, Your Lordship.
This one?
This, Lordship, I need to obtain the instructions because the director office has already communicated with the IS.
Wait, I'll just go to the last order. The respondents have instructed her that Subodh Kolita is continuing the secretary to the government of Assam because in the speaking order dated Iman had held that upgradation of Subodh Kolita from the post of no such upgradation possible under the rules. Accordingly, on the next state of legislation, all the service will be dealt with by the respondent. On the post of LDA, and admittedly he was so reported to the police. So today actually they were supposed to place the instruction as to what will happen to Subodh Kolita because his upgradation is said to be wrong.
Yes, but in my case, I am fighting for the post of LDA, and he is claiming the post of assistant teacher. So facts are different. It would not collide each other. So if this case is taken independently, That will do, my lord. Otherwise,
That is what we are doing, but then they want some time for instructions.
But instruction regarding Subodh Kolita, that is item number 8.
So Subodh Kolita I'm not taking up.
Yes.
I'm seeking a timing for this matter, Your
But
Lordship.
No.
in this case, already affidavit has been filed.
Mm,
Earlier case,
mm.
decision has been taken. I am challenging that order, say, at last page, my lord.
So if the affidavits are filed, you go through the affidavit, we'll take it up now. Right. So this is 2023 matter. Affidavit is filed. Yes, what? Additional affidavit? No.
No, my lord, not in this case.
Huh.
Earlier
case, Your Lordship.
That will cover.
Yes.
In
Because
earlier
facts
case
are
means
same.
item number 8.
9. No.
No, that is item number 8. This is 9.
Earlier.
In the year 2001, I have filed one
Oh,
writ
okay.
petition.
That you have annexed.
Yes,
Affidavit you have annexed.
that is here, my lord. So they only said that there were some corrections.
Mm.
For that purpose, they implicated me saying that, incriminating me saying that I made that correction. So I am not entitled. But prior to
Let us
that-
see the facts
Yes,
then.
yes, that is correct.
Okay.
My lord, fact goes like this. In the year 1998, one LDA post was there.
Wait, show me the annexures.
My lord, kindly come to.
You are
first-
Kandon Sandra Kolita.
Yes,
Okay.
Annexure 1, page 20.
Page 20, yes.
21 is the relevant person.
This
and
is a 99 writ petition.
Yes, this is the first writ petition filed by me
Mm.
claiming the post of LDA.
Mm. What happened? There was an advertisement, you have appeared in the selection process, then you are not appointed.
Yes, although I was in the first position, the Subodh Kolita was 7th or 8th position. The select list was not published and he was appointed against that LDA.
Mm.
Subsequently, he was upgraded to the post of
Assistant, okay. That upgradation is stated to be wrong.
in the other method.
Mm.
So I'm not concerned with that. I'm just claiming my post of LDA.
Mm.
So in the year 2001,
Mm.
1998, this writ petition was filed and 2001 direction was given by this honorable court
Mm.
directing the respondents
Mm.
to consider my case, my lord.
For appointment to the post of LD.
Yes.
Yes, then?
Nothing happened.
Why were you rejected even though you were in first position?
Yes, that is because first of all, the select list was not published.
Huh.
So I have no idea whether I was, although I was, I had the information, but I had no document, my lord.
Achha. So what happened here?
Yes.
In this case, the direction was given to
Direction was-
consider.
Direction was given to the respondent authority to consider.
Where is
my
that?
case.
Where is that? Page
Take up
number?
Page number 23,
Hmm.
last but fourth line, my lord.
Hmm. Accordingly,
Yes.
accordingly it is hereby.
Page 23, last fourth line. It is hereby informed as part of the record as marked as X for identification with establishment the fact that one post LDA is still lying vacant.
Hmm.
It is also made clear that the entire exercise shall be done within a period of 1 month.
Hmm.
So.
No, where is the direction to appoint him? Consideration?
Mm,
Consider the case
consider,
of
yes.
the petitioner on the basis of the available materials and also keeping in mind the factor of
For consideration.
service of the respondent. Oh, you were working as assistant teacher.
No, my lord.
Respondent number 5.
That is the.
Factor of service of
Subodh-
respondent number 5 is Subodh.
Subodh-
As assistant teacher at the moment, not as LDA, as per related order bearing number. Okay, okay. Hmm.
So although within 1 month they had to take a decision,
Huh.
but nothing was done.
Hmm.
Thereafter, my lord, one letter was there saying that things are going on.
By the
For
inspector of schools.
Yes, yes. At page, annexure, my lord, 2, page 25.
Another person, Subodh Kolita, stood first in the selection test and interview,
Yes.
and not the petitioner. Accordingly, the then inspector of school issued appointment to Subodh Kolita. Since then, no appointment has been made due to ban by the government. Okay,
Yes. It
then
was one observation, but no final decision was there.
Hmm.
Therefore, I filed another writ petition. Kindly come to page number 27, annexure 3.
27, yes.
WPC
So his
6779.
case was not considered.
Not considered.
However, the petitioner's case for
Not considered
appointment.
means no final order was there, my lord.
Okay.
Yes.
Hmm.
Thereafter, my lord, relevant portion is at page 28.
Hmm.
Again, my lord, direction was given.
Hmm.
to consider my case.
Mm.
And in the event of anything not done by the respondent, I had the liberty to approach the honorable court.
Shall
again.
examine and consider the petitioner's representation
Yes,
in accordance with law.
yes.
If any issued material as appropriate or whenever whatever decision is arrived at concerned shall be communicated, the whole exercise or directed 3 months. Okay, then
Then also,
what do you say if it is not considered? Petitioner shall furnish. If the petitioner feels aggrieved by the decision, which may be reached by the respondent authorities, he shall be approached this court. Okay,
then also the respondents did nothing.
Mm.
They only said repeatedly meant there was a ban, as
Ban.
stated earlier.
Mm.
So I was also, my lord, I could not do anything. But in the year 2016, they, my lord, they published one fresh advertisement for that post, my lord, for which I filed the writ petition at page number 67, annexure 14. That is the order.
then after that 10 years elapsed.
Yes,
This was in the year 2006 or what?
yes, my lord,
Huh.
2006.
Yes.
So only things they say.
After 10 years, there was an advertisement.
Yes.
Mm.
So I filed this writ petition, and while I obtained the instruction and collected some documents from the office through RTI,
Mm.
I came to one interesting, my lord, document. That is, my lord, kindly come to page number 34 and etc.
Now, what happened after this 2006 order? No consideration. Ban.
Yes, but no final order was there.
But then still there will be some order after this order?
Nothing. my lord.
Nothing.
Subsequently, in the year 2016,
Mm.
I obtained some interesting document. Kindly come to page number 34. It shows
34.
that in between what happened between the inspector of school and the director and the commissioner. Kindly come to page number 34 and
Mm.
6.
Mm.
This is a report submitted by the inspector of school against that direction, 2005 writ petition direction, because the director asked the inspector of school to submit one report. This report was submitted, which was not initially supplied to me, but in the year 2016, I.
You got it.
Yes.
And this report was of 2007.
Yes.
Mm.
And kindly come to page number, serial number, my lord, 2, 3, 4, all are important. And which clarifies the, my lord,
So this is in connection with Chandan Korita 6779.
yes,
So
May I-
67, this is after that Justice Ansari's order.
Yes.
Then,
the serial number 2, my lord.
wait, I'll just read it
Page
from
number
the first.
34. May I read? ma'am?
Wait, I'll read it. I'll read even one.
Yes.
Recording that Subodh Kolita stood first in the interview and he was appointed as LDA. Right.
Yes.
By the then Inspector of Schools. Okay. Final list of these candidates, namely Subodh Kolita first, Chandran Kolita second,
Yes.
Joyanta Pathak third is found available where there is no any signature of the chairman.
Here comes
Another
the
statement of 30 number of candidates showing their marks in details is also found with the signatures. Occurred the highest marks
Yes.
among the 30 number of candidates.
So there were two lists.
Mm,
In the first list, where the name of Subodh Kolita was there,
mm,
nobody signed it, my lord.
mm.
But the second list, which was the original one,
30 number
With-
of candidates.
yeah, with all signatures of that,
Mm.
my lord,
With two signatures.
yes, where my name was there, my lord,
Oh.
at the top, my lord.
Mm,
But as because these things were happened, this corruption was practiced.
mm.
So the second list was, my lord, as per the second list, although
Mm.
there were no signature, Subodh Kolita was,
Mm.
my lord, appointed.
It is found
But-
that the Honorable Minister Corporation had requested Honorable Minister for appointment of Subodh Kolita. Where then the Honorable Minister of Education has issued instructions for, it is for because of the intervention of ministers.
Yes.
Then this
Then, my lord, in the year 2016, when filed the writ petition, the record staged that advertisement. And in
where is that?
My lord,
Where is
advertisement-
the order?
Yes.
What are these letters for? 2008.
My lord, I will refer to that order, my lord, the stay order. I will.
Yes.
Kindly come. I will. That is reflected in the final order also. I
Oh.
will show, my lord. I will satisfy your lord.
So after that number of communication between the authorities.
Yes,
Then-
nothing was done. So I filed this writ petition, and the reply had been filed at page number 63. My lord.
What is this page 48 writ petition?
My lord, this is the writ petition filed by me.
You had also submitted a representation. What had happened? Nothing.
Nothing, ma'am.
And this 286 of 2016, what is this writ petition about?
Writ petition about to appoint me as a LDA.
Then what happened?
Regarding that, my lord, report of 2007 of the inspector of school, where it is shown that in the second list where all signatures were there.
There you had come first.
Yeah.
Then what happened to this writ petition?
In the meantime, my lord, they filed the reply. That is why I am saying that it will cover that, my lord.
Acha.
That is at
Affidavit
page-
in 286.
Page 57, my lord.
Yeah.
In 286, yes.
What did they say?
In this case, my lord, the director said that there were some corrections in my answer sheet. So-
In your answer scripts,
Yes,
there were some corrections.
yes, as they say,
This is a new ground.
yes.
Mm.
So even then, my lord, they said that the marks to be corrected, 2 marks, only difference of 2 marks, my lord.
Between
In-
Chandan and between you and Subodh.
So what is much lower, my lord?
Acha.
The second person.
Mm.
So even if 2 marks are, my lord, shown to be, if we think that it was some correction was there, then also I am at the top of the list. But, my lord, thereafter, when the matter was called for final hearing, the judgment was there, my lord, at page number kindly 67.
Yes.
During the argument, my lord, the standing council for the education, secondary education, and as well as the commissioner said that we will, because they were in the earlier times, 2 or 3 times, they did nothing. So they, my lord, prayed before the single bench, honorable single bench, said that we will definitely take final decision this time. Therefore, my lord, the matter was again sent to the commissioner with a specific time period, saying that you take decision. And
Okay.
in this judgment, that Subut Kolta was also dragged because his upgradation was also not proper, my lord. So there were three directions. First direction was regarding me, saying that to take a final decision against my stand. Second direction was to take some decision, final decision regarding that person, Subut Kolita, who was also implicated as respondent in the 2016 matter. And third direction was to pay fine, my lord, 1,50,000 by the commissioner and the director for the lapses done by them, my lord. Earlier. instances,
Where is that?
my lord.
Where are those three directions?
Yes. Kindly come to page number 77, my lord. Para 35. Thirty-five, 36, 37, my lord.
Acha. So the sought for a leave of this court to take a final decision.
Yeah.
On the basis of the matter so and so. Consider amount, including they have to pay exemplary cost of so and so. And for non-compliance of the directions so and so passed in amount. Before I said amount on or before with the state legal service authority as well. One commissioner secretary with the automated event on before without fail. After the compliance of the order, dated Q1 2021. Okay, then.
Even then, my lord,
So there was a direction for the respondents to comply with the order dated 2/1/2006. 2/1/2006 is the consideration order.
yes,
Consider for the post of LDA.
yes,
Consider the petitioner.
yes.
Then what happened?
Then also, my lord, they did nothing, for which I had to file one contempt petition. And my lord, thereafter, during the pendency of that contempt petition only in the year 2023, whereas this order was of
2019.
2019, in the year 2023, they took the final decision, my lord, at page number 79.
Acha. See, 99 he filed the application first. And 2023, a decision has come. Now he has become overaged.
That is correct, but I am protected.
Some age benefit will have to be given to him. Then?
No, age benefit is not, my lord,
Required.
required in my case, because it is a continuing process, and with the intervention of the honorable court, and there were the stay orders also, as well as the direction also.
So what does the impugned order say?
My lord, this impugned order said that as because those corrections were there in my answer script, so I cannot be appointed as L. And thereafter, my lord, one direction was given by the commissioner, secretary to the government of Assam, to send those answer script to the, my lord, FLC, forensic laboratory, to verify who had done it, my lord. For all these years, those answer scripts were under your custody. I filed 2 or 3 cases. Till 2016, you said nothing. In the 2007, that inspector of school submitted that report that the final list where all signatures were there, I was on the top. That also says nothing about those corrections or anything else. So you are responsible, what, as because I can assume, my lord, to deprive me that respondents.
And this correction in the answer script, this fact was first stated in the affidavit.
Yes.
Filed in the case of 2016 case, right?
16.
2016 case.
Yes.
Earlier, that was not an issue.
No.
So, take me to that operative portion of the impugned order.
My lord, page number 80, 80.
This order?
Yes.
And after...
Before that, my lord, may I, the first paragraph, what were the corrections and what are the difference set of marks?
So, what happened to the FSL report?
Nothing, my lord. Till date, they say have not filed any affidavit regarding that FSL report. Although I am repeatedly saying that this is your duty, the department's duty, to verify who did it if it is done. Otherwise, I must accuse the respondents to the extent that to deprive me, they have done it, my lord.
But this is too late in a day, this FSL thing.
Yes. Yes.
Right.
But the thing, another thing, my lord, since 1998, the school is operated without any LDA.
Achha,
And I have been deprived. That is also to be seen.
Now what happened after the new advertisement?
That is already stayed, and that stay order was merged with that final order, my lord. That relevant portion is yet, my lord, kindly come to page 78, page, para 40. The interim order dated 2nd of February 2016 passed in this case stands merged with this order.
So that advertisement set aside?
Yes.
It was set aside?
Yes. Subsequently, by the respondent authority, saying that because no decision yet has been taken by the respondents, whether they would go with the earlier advertisement or new advertisement, or otherwise my case is already rejected, but no appointment till date, man. Or no advertisement has been published, or any engagement has been made by the respondent.
LDA in which school? This is a school, right?
Yes, Bamundi High School.
Okay, well, show me that impugned order.
Page 79, my lord. Page 80, first paragraph. It shows what type of corrections are there and what is the difference of marks, my lord. First paragraph, page 80. It also says that I obtained the highest mark, 51. Subut Kolta only 19 marks.
That is a final list of 3 candidates,
Yes,
huh?
yes.
And a statement of panel of 30 numbers of candidates.
And the direction is at last para, order section.
Here it is said will be sent to forensic laboratory, right? After examining, verifying the records in respect of being upgraded to this department, fixed responsible, harder loss of certificate and steps for recovery should be made for those found to be harmed. Okay. Shall call for fresh recruitment. So fresh recruitment of LDA. Okay.
But the thing is that, my lord, as because they send the matter to the FSL, so that means it is not yet finalized. Whether it was done by me, whether it was done on behalf of me, whether it was done by the respondents or anyone else. So that means if the matter is not, my lord, yet finalized, so how could you say that I am not entitled? Only because you said that some corrections were there.
No, the
And the
fact
thing-
remains, see, not only that, there are other points also. You were, of course, in the first position in the panel of 30 students, but their signatures are there, but without designation, they said. Signatures of 2 signatures were there of the officials, but without designation. Who were those people? It is not known.
This is the
So that panel list is also not believable, rather. Select list also goes, panel list also goes, and there are manipulation in your answer scripts. So there are so many allegations. Minister had interfered and Subodh Kolita was appointed. His upgradation is also wrong.
my lord,
So
as
now
because-
what are your prayers? Now you want appointment to the post of LDA in that school
Yeah.
after so many
Because of
years.
that Subut Kolka, first thing is that 2 lists were, my lord, there because of that person. Second thing is that so much thing to help that person. That does not mean that my lord select list was wrong, because serial number 3 of that
And what is this last additional affidavit on behalf of oh, Dusty? Okay.
that is
So
the-
this is your case. This is what you have
so
challenged.
the serial number 3 2007 report, my lord,
Mm.
that another statement of 30 numbers or candidates showing their marks in details is also
Mm.
found available with 2 signatures on 25th of August 1998, where it is seen that Chandan Kolita has
But
occurred
without
the-
designation.
My lord, that
Those
thing is not-
signatures were there, but who were those people who had put their signatures? That is not known. Without designation.
that designation word is not there, my lord.
Ah, it's there. You see the imprimatur order? Or elsewhere also I found. You see here, page 80, first paragraph.
Yes, my lord.
4 lines from the bottom, the first paragraph. Where two signatures exist on so and so, but without designation. Got it? Records also
Page
received.
80, my lord.
Page 80. 10 lines from the top, you see? 10 lines, not 10 lines. Ninth line from the top, without designation. So fresh recruitment is contemplated. So you appear in the fresh recruitment and your age, condonation of age and all will be given. Now at this stage, after so many years, 23 years or so, I cannot I cannot give a mandamus that appoint him to the post of LDA. So much has gone by after this.
It is correct, my lord. I am still fighting. That is one thing.
Ha, ha,
Second thing is with the intervention of this court, my lord. Third thing is, my lord, this case projects the, my lord, inability, corruption of the department on the face of the record, my lord. Even then, if I am deprived, my lord, then what can I say? At least from this honorable court, I don't expect to be said that, my lord, as because times has passed, my lord, nothing can be done. Because I am still fighting, I am still continuing the process, my lord, legal process, and so many cases are there. First 2098, 2005, 2016, thereafter contempt case, now this case, my lord. I'm not that I waive my lord right, my lord. That is one thing. Second
But
thing,
again, if an order of consideration goes from this court, again they will sit over it.
no, that is why, my lord, this time because earlier, although I have seen, my lord, so, my lord, few cases where such high cost is imposed, which clearly indicates the mind of the honorable justice, my lord. But as because at the earlier one, in the 2016 one, the respondent prayed that we this time we will definitely take some decision. That is why matter was remanded.
Okay, what do you say, Ms. Charanti?
Lordship, the hearing
There are
was
so
also
many
been
directions.
Lordship, hearing was also been conducted, Your Lordship, on 5/11/2019. Page number 89 of our affidavit. Your Lordship may go through, Your Lordship.
Yes, that is known. Hearing was conducted, and in the hearing,
has
Subodh
already
Kolida said something.
Yes, Your Lordship, he has participated in the hearing also, Your Lordship.
That is in case of Subodh Kolita. Page number 89, there is no page number 89 here.
89 of our affidavit, Your Lordship.
Your affidavit, right?
Yes, Your Lordship.
Your affidavit is at page 57.
No, Lordship,
Right.
the earlier case, Your Lord-
Earlier
earlier case.
Earlier case only, 286.
Item number 8.
Item number 8.
Oh,
Is
and
referring
item
the-
number
is
8.
referring the affidavit.
8 we are detagging
Yes.
because they said that the issues are not same. There, of course, his upgradation is also under challenge. So there the issue is different. But as far as he is concerned, he had applied in 1999,
Yes,
and
Lordship.
then see, many years have gone by. He is fighting. He is correct in a way. And there was a there was a what? There was a direct decision of this court after imposing exemplary cost that you have to follow the earlier decision, and that took so long. That judgment was of 2016, right?
16.
And 23, you had passed the imprimatur order.
19.
19. And 23, after 4 years, you have passed it.
Sitting on contempt.
And yes, there was a contempt proceeding in between. So, okay, I will write the facts and then I'll decide on something. Okay, right. Mr. Mr.
DK Nath.
D.K. Nath, learned counsel for the petitioner, and Miss H. Terangpi, learned standing counsel for higher education, secondary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for a direction, has prayed for what? We prayed for a direction to the respondent authorities to you have also prayed for setting aside of that impugn order, but then it's not there.
My lord, page 17, prayer portion.
Acha, acha, Okay, directing the respondents not to act upon the impugn order. Praying for an order to set aside the impugn order dated 26/6/2023, by which the claim of the petitioner for appointment to the post of LDA
Now senior
in
assistant, I think.
Bamuni High School.
Yes.
Bamuni High School was rejected. The case of the petitioner is that, pursuant to an advertisement in the year, where is that? It is in the order of 99.
My lord,
Pursuant to an advertisement in the year 1999.
98.
98.
Yes.
Pursuant to an advertisement in the year 1998, the petitioner had applied for the post of LDA. No, the petitioner has applied but neither the select list was published, right, nor he was appointed to the said post of LDA, to the post of LDA in the said school. And he submits that respondent number.
In this case,
No.
did not
And he
get
submits that another candidate, namely Subodh Chandra Kolita,
to board call it.
Subodh Kolita was appointed to the post of LDA in the said school. The petitioner, being aggrieved by his non-appointment, had challenged by filing a writ petition, being WPC number 1766 of 1999. And this court, by wide order dated 5/4/2001, had directed the authorities to consider the case of the petitioner on the basis of the available materials. Full stop. It was also observed that one post of LDA was lying vacant, and the petitioner was directed to be considered for the said post. As in the meantime, the other appointee, that is Subodh Kolita, was was promoted.
Upgraded, my lord. That is also under challenge, my lord.
No, upgraded means upgraded the post or what?
Yes. Not post,
Ah.
him as assistant teacher.
Subodh Kolita was upgraded. That will not be upgraded.
That is why the second direction was there by the
Was upgraded, sick, within bracket to Miss Likhide, as I say, to the post of assistant teacher. And the said exercise was directed to be considered within a time frame. In pursuance, In pursuance to the said order, the inspector of schools, what is KDC? Inspector of schools, KDC, or Kamrup District Circle, by a letter to the Director of Secondary Education, Assam, intimated that in the selection process conducted pursuant to the advertisement in the year 1998, Sri Subodh Chandra Kolita stood first both in the selection test as well as in the interview. And as such, appointment was given to him. And that the petitioner could not be appointed. Further, it was intimated that after the appointment of Subodh Chandra Kolita, no appointment was given. No appointment could be given. Could be given due to ban imposed by the government. With the further intimation that appointment of the petitioner would be considered later as per government norm. Being aggrieved again, the petitioner filed another writ petition, that is WPC number. Etu beleg paragraph koi diya. WPC number 6779 of 2005. And this court, by order dated 2/1/2006. আচ্ছা সেইটো date to দিলো, intimation or date to দিয়া নাই. Intimation dated দিয়া 4th of October 2005. 4th of October 2005. After 4 years. They also take long, no, this education department. I've seen in these days, you take so long in passing orders, in complying with court's orders. See, this was in 21 and you have passed the order on 25. This was in 2001 and you have passed the order in 2005. So there are so many contempt.
This is not a order, it is a letter.
It is a letter only, that too.
Yeah.
Of course, okay, covering the issue. So, okay. But before this next paragraph, you write, no, it was a letter. There you say that it is seen that the said information was given by way of a letter and that there was no order of compliance by the authorities pursuant to the High Court's order dated 5/4/2001. তাৰপিছত being aggrieved again, he filed a writ petition so-and-so, and this court by the order dated 2/1/2006 had directed the authorities to pass shall examine and consider it, directing the authorities that they should consider the petitioner's representation in accordance with law and issue appropriate order. And the said exercise was directed to be completed within a period of 3 months. Full stop. It was further ordered that if the petitioner feels aggrieved by the decision of the authorities, he may approach the court for appropriate reliefs. Pursuant to the same, in the year 2007, more specifically on 2nd of November 2007, a letter was written by the Inspector of Schools to the Director of Secondary Education intimating thereby that it was not the petitioner, but Sri Subodh Kolita, who stood first in the interview pursuant to the advertisement of 1998, and he was appointed as the LDA. Full stop. It was further intimated that a final select list final select list of the candidates was found available, wherein Subodh Kolita stood first and two others. Oh no, you are Chandan, right?
Yes.
And the petitioner stood second. Along with the said information, it was also intimated that there was another statement of 30 numbers of candidates showing their marks, wherein it was found that the petitioner scored the highest mark. Full stop. It was also stated that the said list of 30 candidates had two signatures of the authorities, whereas in the final list, in the so-called final list of three candidates, there were no signatures of any authorities. It was also stated therein that there was intervention by the minister concerned for appointment of Subodh Kolita to the post of LDA. And as such, he was appointed. Full stop. Thereafter, there were a number of correspondences between the authorities concerned and the petitioner being aggrieved. Where is 2007 RTI? Oh, that is the one. No, right. That is the one.
It was obtained in 2016.
It is stated herein that the said letter dated 2nd of November 2007 was obtained by the petitioner by making an RTI application, under the RTI Act. Thereafter, it took idea that there was many correspondences between the authorities, right? Being aggrieved, again, the petitioner filed another writ petition, being WPC number 286 of 2015.
Advertisement was there, madam. Press advertisement.
Oh, yeah. It agot dia. That it would line agot dia, huh? In the meantime, there was another advertisement issued by the authorities for filling of the post in the said school, right? In the said school. And the petitioner being aggrieved by his non-appointment and the fresh advertisement filed a writ petition, okay? Registered as WPC number 286 of 2015. Wherein he had challenged
16. 2016.
Oh, 2016 or 2016, huh? Wherein he had prayed for a direction from the direction by the authorities to appoint him to the vacant post of LDA in Bamuni High School. Full stop. In the said writ proceedings, an affidavit was filed by the Director of Secondary Education, wherein it was stated for the first time that some corrections,
yes,
some corrections were seen to have been made in the answer scripts of the petitioner. Parisa? In the answer scripts of the petitioner. That is the only ground taken, right?
Yes. Page 60, that is the paras 7 and 8, my lord. Clear ground, my lord.
Okay.
Overwriting. Page 60.
It's okay, that is the only ground, yes. The said writ petition was taken up for disposal, and this court, by order dated 4/10/2019, had ordered the authorities concerned where are those directions? Yes, yes.
77,
Mm.
page 77, para 35, 36.
Wherein it was observed by this court, it dated so and so, no? Piccolo? Observed that the authorities had not complied with the court's order dated 5/4/2001, passed in earlier writ petition mentioned above, as well as 2/1/2006, passed in another writ petition mentioned above. Full stop. The court had further directed the authorities to pay an exemplary cost of rupees 1,50,000 for non-compliance of the court's orders.
May I clarify just one thing? This amount, the department subsequently filed one review and it was relaxed. It was relaxed
Which was relaxed later.
later.
Okay.
In the review
For
case.
non-compliance of the court's orders, right? Which, however, was relaxed later on an application made by the department
Review petition.
in a review petition. It was further directed by the said order that the Commissioner and Secretary, Education Department, should comply with the orders dated 2/1/2006 and 30/11/2019, which is this order. It is it. 2/1/2006 without fail. With the further observation that after complying with the judgment dated 2/1/2006, the authorities would decide to proceed with the advertisement dated 11/12/2015 or not. Para. The said decision was passed in the year 2019 by this court. However, the authorities sat over the matter and nothing was done by them for years altogether. And that finally, on 26th of June 2023, that is after a period of 4 years, the Secretary to the Government of Assam, School Education Department, passed the impugn order on 26th of June 2023, stating inter alia that there were two lists after the advertisement in the year 1998. One list showed Subodh Kolita as the first candidate. No, as the first list showed Subodh Kolita ranking in first position, with petitioner in the second position. And the second list showed petitioner to have scored the highest mark. and also that the first list had no signatures of the authorities, and the second list, not second list, and the panel of list, no, and the panel of candidates there, and the list showing panel of candidates. I go to second nokoba, huh? Panel of, and the list showing panel of candidates with 2 signatures, but without designations. Full stop. It was also stated that appointment of Subodh Kolita was done at the behest of the minister concerned. Further, it was stated that the answer scripts of the petitioner was found overwritten, and for which the same was sent for examination by the Forensic Science Laboratory. In the order, the authority concerned stated that appointment of Subodh Kolita was not found to be proper on the basis of the list which had no signature. And further that claim of the petitioner also could not be considered in view of the manipulated marks it was further stipulated that the government had not taken any decision. Oh, no. It's stipulated that the government has also decided not to take any steps pursuant to the second advertisement dated 11/12/2015. And as such, it was finally decided that the department shall call for fresh recruitment to the post of LDA in Bamuni High School. The learned counsel for the petitioner submits that the petitioner fought since the year 1999, and although he appeared, and although he stood first in the panel of list of candidates, he was not appointed to the post of LDA in Bamuni High School. And in his place, another candidate was appointed. That too, with the intervention of the minister concerned. He further submits that the issue of manipulation in the answer script was never placed over the years and during the proceedings before the court beforehand. And it is only in the year 2019 that the authorities had stated in the affidavits that there is some manipulation, which they had sent to the FSL for examination.
2018. Affidavit was filed in 2018.
Or 2018, dear.
And the overwriting, my lord, 16 is changed as 18. That much only. Page 80, the order, the third paragraph, my lord. Only manipulation, they said that as in last line, my lord, para third, seen as 16 is observed to be written as 18. That much.
No, apart from that also, you see, answer script of Chandan Kolita was overwritten and corrected by different pens and handwriting, and the mark seen as 16 is observed to be written as 18 in figure, also in words. There were so many, they said. On the other hand, Ms. Terangpi, learned as a standing counsel for the Education Department, submits that anomalies are found in the answer scripts of the petitioner, and as such, he could not be appointed to the post of LDA in Bamuni High School. Para. It is noticed that the petitioner, for his non-appointment to the post of LDA in Bamuni School, had approached this court in 1999 itself and got an order for considering his case for appointment to the said post. But he was not appointed on the ground that there was ban on appointment. Thereafter, he again came before this court and got an order for considering his appointment. The same did not result in any fruitful exercise in favor of the petitioner. Rather, it was found by the petitioner that he stood first in the panel of candidates, but yet, due to intervention of the minister concerned, he could not be appointed. Thereafter, he again approached this court, and this court, after imposing exemplary cost, had directed the authorities to comply with the order of considering his candidature for appointment to the post of LDA. Still, nothing was done for years. And finally, in the year 2023, the impugn order was passed, by which it was stated that there were anomalies in his answer scripts and that the list showing panel of candidates had 2 signatures but without any designation. And as such, his appointment to the post of LDA in Bamuni High School was not given. It is seen that before 2019, the alleged issue of overwriting in his answer scripts was never placed before the courts or by any information. Full stop. It was rather by an application under the RTI Act. The petitioner got the information that he stood first in the panel of candidates, in the list of panel of candidates. And that due to intervention by a minister concerned, Subodh Kolita was appointed as the LDA. Full stop. He obtained court's orders for considering his appointment to the post of LDA. But for so many years, he was not considered. Rather, his candidature was rejected on one ground or the other. First, due to ban on appointment. Second, due to overwriting, due to alleged overwriting in his answer scripts, and also due to absence of designation of the authorities who had put their signatures in the list of selected candidates, in the list of panel of candidates. Further, it is seen that the answer scripts were sent to the FSL for examination, but till date, no report is forthcoming. And the petitioner is not appointed for no fault of his. as such, no, fault of his, and that over the years, the petitioner had also developed a legitimate expectation of being appointed in the Bamuni High School. As such, this court directs the Secretary of the School Education but FSL report is again there. Can I direct? Okay, I'll think over that last line and I'll give it. Okay. I'll take a break for 2 minutes and I'll come back soon. Yes, Mr. Kamar, that Pathat matter. It's still Pathat. Oh, it's still Pathat.
Yes, sir. Completed.
Okay. In this, and if some FSL report comes and all, then they will, another exercise will be undertaken. Okay. I've given that final line. Yes.
The time
It
frame
hope.
should be given.
Petition is disposed of, huh?
Time frame should be given.
Uh-huh.
One time frame should be given, my lord.
Uh-huh. Time frame I'll give. Time frame within 2 months.
Problem.
8 number to talk, 9 number to dispose of. It key number?
59.
59. Oh. Yes, 59.
Yes,
Mr.
my-
Broadcaster.
My lord, these petitioners are.
Affidavits are filed, it seems.
Yes.
Number of them.
Yes.
Who appears for the respondents? Mr. Choliha is there for finance.
Lordship,
Limited finance.
Lordship, Mr. B. Gogoi appears, Lordship, there's some difficulty on his part today, Lordship. Lordship, if any date, Lordship, Thursday or Lordship, today there's some difficulty.
Okay. Mr. Dixit Gogoi will appear.
B. Gogoi, Lordship.
Oh, Buddha Gogoi.
Yes, Lordship.
Okay.
He appears for SSA also, he's some difficulty, Lordship.
Okay. As paid for by the learned counsel appearing for the department. Place this matter on. Port. Day after tomorrow.
Lordship,
Or
next
leave
week,
this
Lordship.
matter on 9th.
Not 9th, Lordship.
Tuesday.
Okay.
Yes, same. Mr. Pulkasta?
Lordship, in this case, my lord, elementary and the finance department is also there.
Mr. Sharma? Have you seen?
They have filed the affidavit.
Mr. U. Sharma, have you seen? This is respondent number 3 has filed the affidavit.
Yes.
Finance department has filed. Mr. Choliha, you have filed your affidavit. Finance is the main party here.
Yes, both elementary and finance, my lord, they are, what is that?
Elementary has not filed affidavit.
Their earlier round of litigation, they have filed, but it's annexed here.
Oh, earlier round of litigation, Mr.
Yes,
Sharma.
yes.
That will cover.
Yes, lordship.
Matter can be taken up for disposal.
I'm ready, my lord.
Ready, Mr. Sharma and Choliha?
No, Lordship. Here also, Lordship, Lordship, I apologize, Lordship. Today, here, Lordship, some accommodation is required in this matter. I apologize, Lordship.
Okay, next Thursday.
Thursday.
Not coming Thursday, next Thursday.
Lordship.
As prayed for by the learned counsel appearing for the department, list this matter on 11th of June.
Lordship, obliged, Lordship.
Done.
Yes.
May I please, Your Lordship?
Hmm.
Your Lordship, this is a contempt petition for the non-compliance of the order dated.
So any instruction, Mr.
My lord, here we are preparing a review petition, my lord. We have already filed, but not numbered, my lord.
When was the order passed?
23/2/2022, Your Lordship.
22. Your review petition, your delay will not be condoned. Review petition, there is no delay or
In similar, my lord, cases pending, my lord, we are challenging the same judgment. Similar batch of my lord, review petition is pending.
you have filed or you will?
Already filed some cases. We have
Acha.
some challenging the same judgment.
Acha. Where is the impugned order? Where is the non-compliance order?
Page 12, Your Lordship.
Page 12.
Of contempt petition, page 12.
Acha, acha. Okay.
Some
We will wait for some time. Let's see what happens in the review. Okay. Justice Medhi. Okay. Mr. B. Bora.
PK Bora, my lord.
PK Bora, learned counsel for the learned standing counsel for
Elementary education.
elementary education submits that the review application has been filed against the order dated
23/2/2022.
23/2/2022. Non-compliance of which, for non-compliance of which, the instant petition has been filed. As such, a prayer is made to take up this matter on a later date. Prayer is allowed. List this matter on 24th of June. By that time, something will be done in the review or not?
My lord, probably will be stay.
We will see what happens in the review of 24th of June. Yes, 44, another contempt case.
Yes.
Lordship, kindly see that last order.
PK Bora. Yes, Mr. Bora. Appearing for us submits that he has received some instruction.
Here process is going on, my lord. I need some time, my lord. I have.
What is
forwarded-
this instruction?
We have forwarded to the finance department, my lord, his proposal. So I need some time, my lord, to approve by the finance.
The order was of 22.
Yes.
Now you are sending the proposal to finance.
Well, we have sent.
Payment of salary.
Well,
No,
provincialization.
Provincialization.
But kindly see the order.
For honor, court's order is 21. What I have the honor, this is by director to the
Here,
commissioner.
This is forward to the.
I have the honor to enclose the evidence and document relating to financial implications. The checklist, particulars, date of effect.
Only 15 days time may be granted, my lord. I'll bring up to date instruction regarding this, my lord.
Mr. PK Bora, learned standing counsel for elementary.
My lord.
For elementary education, places an instruction by which the director of elementary education intimates the commissioner and secretary, Department of School Education, about sending of certain documents relating to financial implications, checklist, etc., to the finance department so as to give effect to the issue of provincialization of the petitioner service, and has further prayed for some further time. No. কি কয় এইটো নহয় এইটো তাতে full stop দি দিয়া হেৰিটো instruction to intimated so and so. The learned counsel as such prays for some further time. It is seen that the order for non-compliance of which the instant contempt petition is filed was of the year 2021. Until date, the order has not been complied with. As such, the learned counsel is given a week's time to get the instructions.
Can it be, my lord, 15 days, my lord? On 16 or 17 of June?
Is given some time, Dilia, some time to get the instructions. That too as a last opportunity. Otherwise, we will proceed with the
My lord, on 16 or 17, my lord.
list this matter on 17th of June.
Can it be part of that?
No, not Pathat. Every court is same.
Yes.
Yes. So many contempt cases in education department. Has to be, they take years to comply.
Going to file wakalatnama today, my lord.
Wakalatnama?
Yes.
Acha.
So sometime I granted.
The respondents were not represented till date. Acha, not many days have gone. Order is of 25. Okay, Mr. U. Sharma, learned standing counsel for elementary education. Oh, yes. Learned counsel for contempt petition, right? Learned counsel for respondent number 2. There are 3 respondents, Narayan Kumar, Momota Hojai, Ganesh Harijan. Respondent number 2 submits that he requires some time to file the wakalatnama that he will file. He will file the wakalatnama and would also file an affidavit in opposition. And as such has prayed for some time. Prayer is allowed. List this matter on 19th of June.
After vacation, my lord.
No, not after vacation, 19th of June. We will see. Yes.
The dispute relates to lordship in charge headmaster of a LP school lordship.
For appointment to the in-charge headmaster.
Yes.
Yes, Mr. Babla Talukdar.
And the
You have the instruction, you have filed your affidavit?
No, my lord, till now.
There is one affidavit.
We have received
Does
the
the-
parawise comment, my lord. Received the
You have
parawise-
received?
My lord, so
Interim order is there.
interim order is there. He is in
service is
service.
completed.
He is in charge. Now he is in charge.
He in charge.
Still in charge, my lord.
He was a petitioner was appointed in the 2012. Husband number 4 appointed in the 2013 in a different school. Then he transferred to my school in 2016. So the law says that once the incumbent transfer from one school to the other school, he will
Lose his seniority.
So his seniority will be counted with effect from 2016 itself. On that account also, I am still the senior.
You are
officer.
senior.
So, but the impugn order is by 14/10/2025, 34. By this order, lordship, the respondent who was allowed to hold the charge.
Acha.
That is the case, Lord.
Okay.
In despite of
He had lost his, the respondent had lost his seniority, but then still, no representation
Yes.
found.
Direction is given to maintain status quo, lordship, but the respondent who is he holding the charge in the office of the BO.
He is holding charge of the,
In charge of the head school at the office of the block elementary division office, Lord.
Acha.
So.
Okay, you file your affidavit soon, and there is no representation on behalf of the private respondent.
No, service completed. I have taken justice service also. Now one is present.
Okay, without their
There
presence,
is a
we
large
can.
amount order lordship.
There is a large amount order
Yes.
also. Okay, Mr. B. Talukdar, learned standing counsel for elementary education, prays for some time to file the affidavit in opposition. Full stop. He further submits that he has the parawise comments, which he would incorporate in the said affidavit. Prayer is allowed. List this matter on 16. List this matter on 19th of June. You file the affidavit. Interim order passed earlier shall continue until the next returnable date. এই পাঠটো বাদ দিয়ক না এইটো মাতকচোন কিবা হিয়াৰিং হয় যদি
There is a timing matter 41, my lord.
46 that hearing matter, right? Mr. Counsel is there. Which one?
41, my lord, timing matter, my lord. No,
41 is left over.
my lord.
আচ্ছা তেতিয়া বেলেগ hearing to মাতক আৰু Pathad, the counsel is not there. Neither Mr. Kamar. Oh, second half. Okay, matter. 47 ki hol? Acha. 48, Mr. S.A. Ahmed.
May I please, the matter may be taken at 2.
Two I've already fixed a Pathad matter, and this is this matter relates 2017. Right.
I am on behalf of S.A. Ahmed. He is legging another.
Is this ready for hearing, Miss?
Yes, your ladyship, this is ready.
2017 matter. It should be disposed of. Call him. But at 2 o'clock, I'll take up the other matter. After that, I'll take up yours. 2017, I'll not get it adjourned. Yes. Yes, Mr. Roy, this is 2018 matter. Who is appearing on the other side? There are so many respondents.
They are the development of the, in fact, main respondent is the government, my lord. The, in fact, my lord, the petitioners.
Government advocate can appear. Kokrajhar Development Authority, Silchar Development Authority,
In fact, my lord, they filed the,
all the Golaghat, Nazira, Sonari, Jorhat.
in fact, the petitioners are the employees of the development authorities.
And why these all districts authority?
Because they are working in the development, they in fact, the authorities are supporting my case.
Acha.
The petitioners are not getting salaries for months together. I think
Acha.
Your Lordship,
So he has worked in all these authorities, in this
that's why.
development authority,
My lord,
by way of transfer and all.
no. There are many development, altogether 24 development authorities.
Acha.
The petitioners are the employees of all those development authorities. They are the association. My lord.
Acha.
They are claiming their, my lord, my lord, their salaries because the lordship will find. If the lordship can look into this, my lord, for a while, my lord. I think
The president and the general secretary are the representatives. Okay. Oh, yeah, this.
kindly see this. The authority, the employees, my lord, of these development authorities are not getting salaries, my lord. The lordship will see for
Yes.
50, 24 months. Presently, the petitioners are only on they are ensuring their monthly salaries. In fact, it happened.
They are getting their monthly salary.
They are not getting.
They are
That's why, my
not.
lord, that's why, my lord, they are there.
And they are working since?
Since whenever, now they are only paid, 500, 600 lump sum amount. They are all regular employees in a definite, working in a definite scale of pay. Now, my lord, the government says, since the authority is independent, they provide fund, but not the salaries. The Supreme Court, my lord, I will place before lordship, say, hell, this is a human right. The government must take the responsibility for paying salaries in time. And in fact, my lord, the government says that you are independent authority, but for the employees of the municipalities and the panchayats, their salaries are ensured, my lord, but not of us. That is the difficulties, my lord. And I can, lordship will kindly have this issue.
What is the reason for not paying their salary?
They say it's not the authority is independent, they generate their own revenue and then pay. And this honorable court was also on earlier 2 occasions. My lord says that you formulate the service rules and all, nothing has been done. CPF, many employees are retiring, my lord, without getting the gratuity and other benefits. That's the thing, my lord. So,
I mean, these authorities are not under the government departments.
Government has deep and pervasive control. Every appointment made have to be approval of the government. So the government provides funds for many other things, but not for salaries.
But government is not the appointing authority.
Government is not. Or development of that, that's it. But the government has deep control.
They are in a way independent authority.
Yes, that is independent under the Town and Country Planning Act. That's there. But if a lordship, I just raise your lordship one decision of the Supreme Court, one paragraph small. Your lordship kindly have a look. I am not saying that the lordship can issue a writ of mandamas. That's right, but the Supreme Court has clarified para 37 of that judgment.
37.
Lordship para 37. My lord, though we have many other prayers, but I am only restricting on para 37 of lordship kindly see. Though it starts from para 22 honorable, para 37. I read it, my lord. We make it clear that we have not issued the aforementioned directions to the states of Bihar and Jharkhand on the premise that they are bound to pay the salaries of the employees of the public sector undertakings, but on the ground that the employees have a human right as also a fundamental right under Article 21, which the states are bound to protect. The directions which have been issued under so and so. So the Supreme Court has other decisions also has made it clear.
Yes, they have their services are being utilized. They have to be paid. Article 21 violation is there.
That's right. Exactly. That's what the Supreme Court has said. So this must be. And for everything, Lord, budget and every government sanction has to be, government approval has to be there in each occasion. The employees appointed are beyond the scale of pay, beyond 300, 400, government approval must be there. So government has the control. Government looks into everything. So why not my salary? That's the thing. In view of this decision of the Supreme Court, government must ensure. An earlier occasion, I can take a lordship with documents. My lord, the authority initially said, my lord, that we presently do not have fund. That was their stand initially. Your lordship kindly have a look at page 59, my lord. What the
government is not giving any funds. It is for them to generate.
The government is giving, there is a provision under the town and country plan to provide fund.
Hmm.
They are also generating, it's true. But problem is now, the earlier, development authority had an area, wider area. Now, after the amendment of the municipal act, their area have been taken over by the municipality
Hmm.
and also by the budget, though they are in a very small area. Fund generation is very poor. The development authorities have filed the affidavit in opposition. They said, how can you do unless the government provides us fund, I cannot provide for. That is their stand. And they will have to say this below. So government has to ensure. Now, my lord, for the municipality employees, the government is ensuring payment, my lord. The panchayat, the government is ensuring every month they're getting.
They are also similarly situated like development authority.
They are also independent local authorities like us. That is our prayer. I can lead or my lord, to take your lordship the various orders, but then my lord, the primary, if my learned friend ready, I can also my lord, I'll go on the mail where it take your
Yes,
lordship.
yes. You can.
Lordship.
59 page, what are you showing?
59, my lord, the government stand earlier. Lordship will kindly, that was written in 2002 to the General Secretary of the Petitioners, Petitioners Association. So it says, my lord, that this is in response to various demands made by us. Says demands like provincialization service, provisions of salaries of staff and sanction government for loan taken by the development are difficult to accept in view of the financial problem being presently faced by the government. That was in 2002. Otherwise, they are ready. Now, after 2002, it is 2026. They cannot now say, my lord, they would not have fund. They cannot always cannot have fund, my lord. Now, my lord, as far as the sanction of funds for implementation of different schemes by the development authority is concerned, government can accept this demand and funds can be subject to availability to the planning and development department. Uniform service rules of the employees of the development authorities are being formulated and are likely to be ready very shortly.
Has it been
not
done?
It is
Not
not done till today. So, my lord, these are the, though we have many other demand. But primarily, we are concerned with ensuring our monthly salaries. That is the only. Now, my lord, if lordship kindly come to page 80, 79 is the page 80. My lord, that was the, and in fact, it starts at page 17, and that was the order passed by earlier. Earlier, my lord, when you approach this honorable court. My lord, page 80, lordship will kindly see. The second para. The Assam Town and Country Planning Act 59 and the rules framed thereunder cast a duty on the authorities to make rules with the previous sanction of the government with regard to the various service conditions of the employees, including establishing and maintaining provident fund and retirement benefit, including the gratuities. But the said benefits are not ensured till today by framing rules. The petitioners do not get their salaries in time. Some of them are getting wages at a very poor rate and have been working as such for years together. They retire without any retirement benefits. Their representation from time to time yielding no result, and as such, they are not left with only remedy to approach this court. The Petitioners' Council pointed out that the letter, Deputy Secretary, Government of Assam, Planning Department, General Secretary, so their letter was given. And
the one you have pointed out.
Yes. Then, ultimately, it was directed to the government to give a reasoned order. The government has passed this order now. My lord will kindly come to page 83. It's 89. 89.
Where is the direction here and by this court?
Well, the direction.
I direct the principal secretary and it considered a grievance made out. Okay.
Then, my lord, the government has passed the order. They ultimately they say that they provide fund and all. Now, my lord, they said that page 92, they said they are giving various funds for other purposes, and these are all given by the central government. Now, ultimately, my lord, they say at my lord, at page 94. Further, para 2, further it may be mentioned that developers are required to collect fees and other revenues on their own to carry out their activity payment of salary. So, my lord, on the one hand, their area of operation has been taken away now because municipality, they do not have any revenue generation provision. And they said how can they will not generate fund? The municipality authority has also, I mean,
The
development-
grants received from government annually is only to supplement such efforts. Only as a subsidy, as a.
Salary will not, must be ensured. That is not supplement, that must be ensured. Development authority, if Lordship kindly pay, look at. My Lord, kindly take up page 122. This is one of the development of this. They all are similar line, 122. My Lord. This is the affidavit filed by the Development, Silchar Development Authority, similar on the similar line by
122, yes.
122.
Hey, at a paniye no water. 122, right? Yes.
Serial 122.
Huh.
This is an affidavit filed by Silchar Development Authority.
One page affidavit.
There are other also, 122. This is the affidavit in opposition filed by Silchar Development Authority. If Lordship kindly come to 123. Lordship got it.
There is nothing.
Paragraph 4. Paragraph 4. Lordship got 123 page serial.
123 days, nothing. In fact, this is an affidavit by respond. This is what? Dusty. This is Dusty service. What affidavit?
Affidavit in opposition filed by Silchar Development, one of the development authorities.
Wait. These are all service notices.
One is respondent number 6.
Respond number 6. Additional affidavit. Respond number 4's affidavit. Respond number 6 you're talking of.
Yes.
This is Dusty. No. Wait. This. Respond number 6, you said?
Yes.
Respond number 6, yes.
Lordship got it.
This is actually page 148.
Oh, maybe we wrote that.
Okay.
In fact, my Mr.
Paragraph
filed by
4.
Mr. Jalal Ahmed Mujumdar.
Yes. Jalal Ahmed Majumdar.
Yes. My Lord, can you come to the next page, paragraph 4. That with regard to the statement made of 1617 writ petition, department begs to state that, like the other development of the Silchar development authorities, have one employee working in their office, deputation, different directorate. The employees who are working in the Silchar development are getting equal scale. My Lord, in fact, these are the deputationists from the government. They get regular salary and work same work like us. The employees who are working in the Silchar department are getting equal salary and pay so and so. But due to positive fund, more so due to the amendment of made in the 1992 Assam Town and Country Planning Act and Assam Municipality Act, monthly salaries the employees of the Silchar development cannot be paid regularly in time. However, the department begs to state the employees of the Silchar development do not get the retirement benefits like gratuity so and so. So because
only one employee working on deputation is getting.
That is deputation is from the directorate of it.
Town and Country Planning.
So he gets salary. But the others who are appointed by the development authorities are not getting because of financial crunch. They do not have, they cannot generate fund. Similar, the other development also filed on the similar line. Same. Now, my Lord, the government now say.
What is amendment in 1992?
This is the, after the Municipality Act has been amended. By
what effect it has got in this case?
The area of municipality is widened, taking away the areas of the development. So their fund generation is very difficult. That is the problem. And some areas are also taken by the the panchayats. So they are in a very narrow campus. That is the problem.
So here it is said due to paucity of fund they could not be paid.
Yes. So fund. The government says in their affidavit that you generate fund. How can we generate, my Lord?
Where is that generating funds?
My Lord, the government page 94 of the writ petition. They say you generate fund and pay. So this is the difficulty. But the Supreme Court says you must ensure this. After all, it is a human problem. My Lord. After all, they're right under Article.
So these development authorities are under the Town and Country Planning.
The Town and Country Planning. And these also provides when the Act and the rules provides, well, the the service rules are to be framed, the CPF rules are to be framed.
This has not been done.
Nothing has been done.
Maybe
Does
they
it
will
also-
they will do away with these authorities.
So that's ultimately, but we also say that our services should be provincialized. They can easily do this. As they're doing in the municipalities and so, they're getting regular salaries. But for us, they're doing nothing.
You have also prayed for provincialization
That's
as well as
that also.
salaries.
Yeah.
Then what else?
Now, my lord, this is the prayer. So, though I have also prayed for provincializing law, my prayer at the present, my lord, is only with regard to the payment of monthly salaries. That is, the government may provide fund. The Act also says the government has to provide fund. I'm not saying for salaries. The government can. My lord,
Provide funds as a supplementary.
yes, they can do this, my lord.
You don't have any authorities doesn't have any regulation, any memorandum, anything?
Authorities are under the Act only.
Yes, there's this
So-
Town and Country Planning Act,
Yes.
but for their
How they can generate fund, that is also provided in the Act. Getting loans and all from the other authorities. For getting loan, they cannot make payment.
so generating funds and all. Give me the Town and Country Planning Act.
That.
Yes, and yeah, Amanda. Isn't it?
It is
Town
there
and
in the
Country
affidavit, your lordship, the
Ah.
relevant portions. Let my senior finish, then I'll come.
You can say he has already finished. No, Town and Country Planning or Assam Municipal Act.
It is there.
It will be in the Municipal Act.
Yes, your lordship.
Assam Municipal Act,
Municipal
no?
Act, I don't think it'll be there, but we have annexed in the affidavit, your lordship.
Oh, acha, where is that?
My lord,
Affidavit filed
lordship
by
will kindly see
respondent
my
number
lord,
3.
section 48.
Respond number 3.
Respondent 4, your lordship.
Or respond number 4 I've got, yes.
Yes.
Oh, acha. This is, yes. Country Planning Act and
Relevant
rules.
portions, your lordship, I'll take your lordship to that relevant portions. That
My lord, section 48 to 49 of the Town and Country Planning Act.
48, 49.
48, 49, 50.
at page number 174 of the affidavit.
If your lordship has this book, my lord, the Town and
It
Country.
is there in the affidavit. We have annexed.
No, in the affidavit you have
All right.
annexed a portion of the Act and rules.
Yes. What my learned senior is actually pointing out, Rule 48. I am taking a lordship to that page number 174.
No, I think the pages are different. Here your
Pages are different.
Act and rule starts from page 195. What page you have said?
Mine starts at page 169 somehow.
There is another page number that also is not. Yes, 169. Yes, okay. That is a second page number.
Yes.
What is your page number? 174.
174.
Acha, acha. Okay, yeah. This is actually 200 here. Okay, 48.
48, Development Fund.
Yes, Mr. Roy, 48 I've got.
48 Development Fund, that's right, my lord. 48, it says received of authority under the Act shall be from separate development fund, and all expenditure under this Act and development scheme thereunder shall be defrayed out of such fund. No portion of fund except the sanction of the government be expended for the purpose not provided under this Act. Then power.
They'll have a separate development fund.
That's right. It's there. But now they must generate fund, my lord. That's the problem. The power of borrow. Authority is defined under the Act shall deem to local so and so, local authorities under so and so Act for the purpose of borrowing under the Act.
Which
and
one? Which one are you reading?
section 49 of the Act.
Okay.
And section 50. Grants, advances. The government may make grants, advances. That I'm on these, my lord. The government may make grants, advances, and loans. If the government can make grants, why does it not include the salaries?
But as it may deem necessary for the purposes of performance of functions of the authorities.
The employees, it must include that, my lord. It is for the purpose of the Act, my lord. It is not beyond the Act, my lord, beyond the purpose, my lord. The employees are working for this. So, my lord, my submission is, in view of this, my lord, provision, as well as what the Supreme Court has held, the government must ensure. That is the thing. I am not asking for you regularize our salary. You may have some problem, but you must at least ensure payment of our monthly salary.
This is all?
This is all.
Yes, Mr. Bora, what do you want to say?
Your lordship, first and foremost, your lordship, instead of going to a particular section on a piecemeal basis, I would like to start from our affidavit.
No, he has a simple case that People
Yes.
are not paid.
The genesis.
Government has a duty to give
No.
grants and all.
Only grants may, if your
Of course,
lordship,
if deemed necessary.
if deemed necessary.
Coupled with Article 21, they should be paid their salaries.
Your lordship, the thing is, the mandate comes from a particular section, an act of the past state assembly, wherein this provision is already there as to how these funds will be generated. And for that, if they have any problem, then they have to challenge that particular section, first and foremost. Secondly, your lordship, this whole genesis of this claim, government has got nothing to do with, because these development authorities are autonomous bodies. They are a creation of a statute. And in the statute itself, a mechanism is actually enshrined as to how they will generate funds. For that, your lordship, I have to take your lordship right from the beginning as to how these authorities are actually under which provision of law they are set up. So for that purpose, your lordship, if I may take your lordship to our affidavit filed by the Town and Country Planning Department, response number 4, which your lordship is taking, page number 158, para 4. And I'll take your lordship to the relevant provision which is mentioned therein. Your lordship, as per this section 8G2 of the Assam Town and Country Planning Act, the authority may appoint of such members or officers and employees as may be necessary for the efficient performance of his functions and may determine the designation and grades. This is mentioned in 8G2, which is your lordship will find at page number 169 at the bottom, your lordship.
8G2.
8G2. The officers and employees of the authority shall be entitled to receive such salaries and allowances, if any, as may be fixed by the authority, and shall be governed by such terms and conditions of service as may be determined by the rules and regulations made in his behalf. So, who would pay this particular salary? Authority. Now, your lordship, if I may take your lordship, further, rule number 17 and 22 of the Assam Town and Country Planning Management Rules 1963.
Achha, just a second, I'll just mark it.
Yes.
8G2.
8G2. The officers and employees of the authority shall be entitled to receive such salaries and allowances as may be.
Which one?
As may be fixed by the authority.
Which one have you read just now?
8G2. Page 169.
Yes, shall be entitled to receive, if any fixed by the authority. Yes.
By the authority.
Authority is what here? What is
The
authority
development
defined?
authorities. The development authority.
The development authority. देखते हैं कितना देर होगा. How long will you take?
Some time will be taken.
Okay, continue for 10-15 minutes. Yes. Then?
So, thereafter, your lordship, all the salaries and allowances will be paid by the authority. The language says that the authority shall, mandatory, the authority will pay. Now, if I may take your lordship to rule number 17 and 22 of the Assam Town and Country Planning Management of Authority Rules 1963, wherein the power of appointing and promoting officers and servants of the authority rests with the authority itself. Now, that is, we have annexed, your lordship, at page number 173. If I'm not wrong, your lordship.
170.
173.
Now tell me, where will they get the funds, authority?
They will develop their own.
Where is it provided?
That is provided, your lordship. I'll take your lordship to that.
Achha, okay, 173, what do you wanted to show?
Your lordship, with regards to this power appointment, that is in fact further to 8G2. That is also in the rules also, it is there. Now, if I'll not take much of your lordship's time, now the as per this affidavit, your lordship, the authority shall from time to time prepare and maintain a statement showing as per Rule 22 of the Assam, page 159, your lordship. Rule 22 of the Assam Town and Country Planning Rules 1963, the numbers, grade, designation of officers and servants other than employees who are paid on daily basis or whose pay is charged to temporary work, whom it considers necessary and proper to employ, the amount and nature of the salary and allowances to be paid to each officer and servant, and any post the monthly or the maximum monthly salary of which exceeds 300 rupees are subject to the previous sanction of the state government. Now, similarly, the matter is also defined in Rule 27 of the Assam Town and Country Planning Rules 1961. It is seen that the development authority has not taken the previous sanction from the state government as stated above. Also, this is very important, Your Lordship, from my affidavit, there is no any rule or act of payment for payment of regular salary with other service benefit to be provided to the employees of development authority by the government of Assam. Instead, as provided in section 48 of the Assam Town and Country Planning Act 1956, development authority shall form a separate development fund, and all expenditure under this act shall be defrayed out of such fund. There are enough scopes to generate the revenue in the development authority by implementation of development schemes as stated in section 15, 17 and 18 of the Assam Town and Country Planning Act, and which have annexed in our affidavit also. And the authority may make the payment to the employees as stated under section 48.
So there is number of scope.
Number of scope. Now, if the development
But then they are saying that they are not been able to generate.
So, as such, the act itself mandates that the government has got no role to play. If I may take your lordship to section 48.
Yes, I have seen.
The
Only grants,
yes.
whenever necessary.
The government only provides the grants. In fact, we have mentioned in the affidavit also filed by respondent number 3, the Urban Development Department. Wherein
You do one thing, you consider paying the...
Already that had been considered in terms of the earlier High Court judgment. We have, it is at page number 89. Now, since my learned senior had actually taken your lordship to one particular paragraph of that particular, but I would like to read out the whole order, the speaking order passed in terms of as to why we cannot pay any kind of salary allowances to the employees.
You are for the government?
Yes, your lordship. As to why we cannot pay any salary.
Of course, in the act it is said, government will only give grants.
That is what.
That too when necessary. You have to generate your own funds. But whether something can be done for payment of salaries to them.
Lordship, that's a policy decision only the government can take, your lordship. I have to...
So think about taking a policy decision.
Your lordship then may dispose it of and direct the government to take a policy decision as to whether it can be paid or not. Because the government...
I'll give some reasons there that although it's only grants, but then Article 21 provides in Supreme Court judgment, they will consider making a policy. No, it is from some other place.
Some emergency alert.
Emergency alert, why?
IMD has issued forecast for thunderstorm and lightning and surface wind along with glide.
Gauhati has issued forecast for
This alarm is alarming. Yes, okay. So what I'm thinking of is because of the weather, no?
Yes.
And so what I'm thinking is you think of framing a policy decision, take a cabinet decision.
Cabinet decision. It has to be placed before the cabinet.
Okay, I'll pass an order in that similar line.
Lordship will give
After quoting Supreme Court.
Your Lordship will, yes, Lordship will give a positive direction. So that's my ultimate Lordship, so that the poor employees will not there get their monthly salary. This is a human problem.
Yes, I understand.
That's
the only, your Lordship.
When they are giving their services, they should be paid properly.
And the deputation is doing the same job. They're getting salaries. My fellow employees.
Under the Assam Municipal Act itself, under section 53, it is mandated there. ACS officer is there, deputed there. So that is a different thing altogether.
Municipal Act and all those are different.
As well as the Town and Country Planning Act also provides so. So deputation is out of this question because that is a different thing altogether. They are different grade, different service.
Deputation, he will get it from the parent department, so he will get it.
That's I'm saying
a different issue altogether.
The equal pay for equal services. That's the thing. That's only. Lordship will consider that.
No, your lord, that deputation is totally different, your lord. So the mandate.
I'm not saying.
No, that is okay. Deputation parent department
yes,
will pay. Borrowing department has got nothing to do, but it's okay. But here, of course, I'll pass a decision that they will frame some guidelines, frame some policies.
And
government will consider, your lordship.
Lordship will give a time frame, so that.
Just that your lordship may also observe our statements made in the affidavit.
Yes. You are correct in saying that.
Yes.
Okay. Okay, we'll dispose it off, but 2 o'clock I have one matter. So I'll dispose it off in the chamber. Matter is otherwise disposed of. Ouch, yes.
Always a pleasure.
Thank you. Yes. Make it short.
Yes, Your Lordship.
Okay.
Yes.
I already have your written argument with me.
Yes.
So written argument koro, sir.
I
Written
will
argument is
pinpoint, Your
there.
Lordship. I will
You'll also
pinpoint,
give one?
yes.
Okay. No, inside that paper book, etu ki? No. Etu sir, tapi sir after that, yes. This is your written argument, right? Hey, come, sir.
Short, brief written.
Ha. Ekhane hobo, sir. Oh no, this is a judgment. Huh? No, file to nai yate, file to nai. He has handed over a written argument, good ba good. Chosum tate ase gobat. Kiyo belek file? These are the paper books. I've told them to keep it, but huh?
May I supply another copy, madam?
No, it's okay.
Lordship went through it last time.
Uh-huh. I kept it in the file, but it will be in some file. Okay, if you don't mind, then supply me one more copy.
So that we could okay.
Ekhon ki? Ekhon judgment. Etu judgment. Okay. Make a photocopy and give it later.
Oh, I can.
In the meantime, I'll hear her. Egita koi belego. Non-payment of public sector. Oh, এই দুটা হেৰি দিয়কচোন এই দুটা যে জাজমেন্ট ৰিজাৰ্ভ কৰিলো yes you don't have a copy it seems right
I have a copy, right?
okay
Yes.
oh I've seen this এখন আছিলে मैंने बोला कि फाइल में ही रखने के लिए बोला था okay
May I please, Your
it will be in the file I'll return back to you
Obliged.
yes Miss Kumari
I shall start with the judgment because it is a well defined judgment and reasoned order is there. Thereafter, I shall collaborate with my other thing. My judgment will, it is in their appeal, Your Lordship.
huh
At page number 32.
page number 32
Page number 32.
yes
I'm skipping other thing and recital clause. It is from paragraph number 5, Your Lordship.
1 second
I have perused the entire evidence on record and have also heard argument put forward by learned counsel for both the parties at length. Also perused the written argument. It has been submitted by the learned PP, CBI, K.R. Ganesan, virtually admitted the fact that alleged amount was recovered from his possession. And as such, it is the duty of the defense side to prove that the said money was accumulated through legal way. Special PP CBI has further submitted that though in the present case, the defense side has made a desperate attempt to prove the innocence of the accused by way of examination of T.N. Khimre as DW1 to substitute the fact that the alleged money was paid to the accused by DW1, but it has not been established in the case that Mr. Khimre paid the alleged money to the accused as claimed by the accused. Also, the learned counsel for the CBI has submitted that the statement of the accused regarding the accumulation of the alleged money clearly proves the fact that the said money was not accumulated through legal means and he has failed to satisfactorily account for such accumulation of the money. Accordingly, learned PP, the prosecution has been able to prove the allegation against the accused as such the accused is liable to be convicted in the case.
yes
On the other hand, the learned counsel appeared for the accused K.R. Ganesan has submitted that the valid consent was not given to the CBI by the state government to investigate the case.
will you read the entire judgment not required
But this will clear everything. The total base is this and that which I will corroborate.
but then you know the
But
procedure
the-
in the appeal we will not go into the judgment not
we
required
have to appreciate the evidence, Your Lordship,
huh.
in appeal.
that you appreciate you
So
show the evidence
appreciation is here. So my concern is that one X amount has been recovered. Their contention is that the state has filed an FIR. Another contention is that this has been not given to the CBI. there is a violation of BSP Act 5 and 6
First, they say that the FIR was lodged on the basis of a confession made by the
no, recovered,
accused.
and he cannot able to account for. And
Mm.
thereafter, he has confessed.
Hmm.
So even if 164 is there, we will discard it. Then even the accused person could not able to give us a cogent evidence, the source of money.
Hmm.
It's recovered. It is an admitted fact, X amount has been recovered.
Hmm.
That has to be verified from the accused whether it is a legal or illegal money.
Mm.
What is the source of income? At that point of time, he was working as a chief general manager in the BSNL.
Mm.
So he has failed to do.
Mm.
He has tried in 4 layers
Mm.
to satisfy the investigating agency or in the court below that these are the legal money.
Mm.
So he has established 4 theories, Your Lordship, to cover his this corrupt means or the source of income. The first theory comes at the very beginning when he was caught there at the airport.
Mm.
When they have found something incriminating in the bag while it was sending through the X-ray machine, he said, I don't have the key. He was adamant to hand over the key to open and to search it.
That was a briefcase. That was a
briefcase or bag.
Mm.
Bag. It is written as a bag.
Mm.
So in that event, since he was adamant to give a key, he said that he don't have the key
Mm.
in his possession.
Mm.
So what happened then? That has been informed to the executive magistrate.
Mm.
When he came, then he handed over the key.
Mm.
And subsequently, 2 keys has been found in his possession.
Mm.
So first theory, he has tried to avoid or deceive the investigating agency by way of saying, I don't have key.
Mm.
Now the second theory, what he has taken in his defense,
Mm.
that the said amount is given to him when it has been recovered and opened.
Mm.
He said that said amount has been given, that X amount has been given to him by MS Pragjyoti Construction. And he has shown one letter,
Mm.
money receipt.
Mm.
Pragjyoti is for the purchase of article.
Mm.
That is Exhibit 4, Your Lordship.
Mm.
I am coming to...
Exhibit 4, where do I get? In the
Yes,
paper
it
book?
is there at page number 16 in the paper book.
Paper book 1.
Paper book 2.
2.
Volume
Two,
2.
just- Mm. Mm. Page?
16.
Mm. Yes.
This is Pragjyoti Construction.
Exhibit 2.
Yes, Your Lordship, this is Exhibit
This is
4.
part of
4.
some bill.
4.
This is some bill.
No, Lordship, to whom it may concern, this is a money receipt.
And
This
then
is to certify that we are sending an amount of rupees 5 lakhs only in
no,
cash
no,
to
that
Bhadra.
then the page number will be different.
Page 16.
16.
16.
Oh, I'm seeing 60.
No,
Okay,
16.
yes, 16. Mm. Mm, yes. Mm. This is by Pragjyoti Construction.
Yes, he has taken this defense
Mm.
that this amount has been given by X.
That we are
Pragjyoti's-
sending an amount of rupees
which he
50
told
lakhs.
there during the
Mm.
course of investigation in the airport
Mm.
or in the Thana.
Mm.
So this he has taken the plea.
Mm.
So this has also doesn't come under his rescue during the course of trial, and he could not able to bring any person
Mm.
to depose on this document.
Acha.
And however,
Mm.
otherwise also by bare looking to the signature of this for Pragjyoti's,
Mm.
Lordship can see the signature Q2. It has
Yes.
been sent to the forensic. This by bare eye, we can make out that this is a distorted signature.
Mm.
It was made.
Where is the signature for Pragjyoti
Yes,
Construction
yes.
Limited?
Yes.
And
But
this
he
signature.
never appear
Mm.
or none of the person has appeared in his defense.
Mm.
So this his plea has gone.
So who has proved this otherwise? This
Prosecution,
which witness?
IO.
IO.
IO or some witness is there because it has already been proved by 4/1.
The
Exhibit.
charge was
Mm.
that this document was given to aid the accused. That was the charge. Pragjyot's constructions, Mr. Agarwal, was discharged by the trial court.
Yes,
That
I'm
you have
coming
said.
to that. I'm coming to that. He was discharged by his, because during the course of investigation and subsequently it has come to the, now the truth has been unfolded that this document is not the signature of Manoj Agarwal. That is why he has been discharged. So this defense has also gone. He never come in the aid of them. Never come in the aid of them. Now, third plea, what they have taken, third theory. Third theory is that when there is an disproportionate asset or the unaccounted money is recovered from any public servant, then the matter is referred to the income tax department also. So income tax department has also made an inquiry. During the course of inquiry and while taking the statement, his statement is accused said that he has taken this money for the purpose of some charitable trust. So these money are taken as chanda or somebody has donated. To that effect, he could not able to produce any document. Maybe he might have taken this amount for the charitable purpose or somebody has given a chanda. But during the course of trial, in defense, he could have called the trustee or one of the person from the trust and he can show that
But
he has,
then what he said is that he had taken money because of some diamond to
I'm
purchase.
coming to that fourth theory. That is, I am coming to that fourth theory. These are the theories.
So here you mean to say that it was, he stated that it was taken
he
for
has
some
stated
charitable.
in different place at different point of time, different statement. Just to cover that X amount, to save the X amount or to save himself from this prosecution. So his third theory, during the course of investigation, when income tax authority has made inquiries, he has said that he has taken the money for a charitable trust located at Madras. That I am coming. His statement is there.
You have incorporated this in your written argument, right?
No, I have not given the written argument.
No, you will.
I will give then if it is required. Page number 30 of the volume number 1.
Volume number 1. Page number
30.
30.
30. It starts from 25 and 26. I am coming to the operating part. 30. These are also exhibited document because he fall under the disproportionate asset and that is why 13(1)(e) has been registered.
This is the statement of PW9.
30.
CW.
CW.
CW9.
CW.
PW. The handwriting is very difficult to read. Acha, then?
The statement of Sri K. Ganesan, Chief General Manager Telecom Task Force, recorded under Section 131 of the IT Act on 22/9/97.
Where are you reading? Page 30?
30 of volume
1.
2.
Oh, volume 2.
2.
You said
Exhibited.
volume 1.
No.
Volume
Because
2?
these are the taken by the income tax department.
Wait. Volume 2, page 30.
Yes, sir.
Yes. This is 161 statement or what?
No. This has been recorded under Section 131 of the Income Tax Act.
Okay.
When there is a question of disproportionate asset, then the matter has been referred by the CBI to look into that angle also. Had the maybe this amount, X amount has been referred in the income tax return.
Yes.
To verify whether it is a legal money or illegal money. So that is why usually it has been referred to the tax department. So page number 30. Statement of Sri K. Ganesh, Chief General Manager, Task Force, recorded under Section 131 of the IT Act in continuance to the statement recorded under 19/9/97 at the Office of the Superintendent, District Jail, Gauhati. You had answered as per question number 12 that you would be giving the detail of the donation received by you on behalf of the trust. Today, on 22nd September 97, now can you please provide the name and address of the donor? What I am just before said, that if he is saying that he has taken the money for the trust, he
Go
can
to the
show
answer.
document in his defense.
I'm not in a position to give the
I'm
names.
not in a position to give the name and other details of the donor. I feel the names are available in the diaries, which may be available in my residence and office at Gauhati. Then next question, how is it possible that when you have been especially deputed to collect the donation for a charitable cause, you are not in a position to give even a single name of the donor? I am in a state of acute mental shock and stress as I am under detention for past 16 years. Fine, he was in the acute mental stress. But at the time of DW, he could have bring all this document in his defense. He never did. He never did. Now, question number 8. Did you give any name to the police at the time of seizure case? No. Then I am coming to 32. Whether you are accompanied by your family member, if so, who were the member? Only Saudi Arabia, when he has gone to the UK trip and this. I am coming to the question number 20 here. Please state some names of the contractor who are having a work connection with you. You can get the names from my office. I cannot remember the names. Did you know the following person from the Bharat Kumar Singh, Sri N.K. Maheshwari, MS Pragjyoti's Enterprise? Answer, N.K. Maheshwari is manufacturer of REC home pipes and one of the supplier of the task force telecom department optical fiber cable, whom I know, and Sri Bharat Kumar Singh is the employee of Sri N.K. Maheshwari regarding the firm MS Pragjyoti's Enterprise. I do not know the firm. There he has produced one Pragjyoti certificate. Here he said, I do not know the firm. Their name is that some signature is there. Now here he is saying, Bharat Kumar Singh is the employee of N.K. Maheshwari regarding the firm MS Pragjyoti's Enterprise. I do not know anything. So for his defense, he has manufactured various documents. Now I am coming to the question number 23. Please state how much rent you are receiving from you let out property at plot number 163 at Palanipa Nagar, Valsar, Vakkam, Chennai. I am receiving rupees 1,000 per month since last 2 years. Now question number 25. You have managed to apply your mind and answered most of the question put to you, but regarding basic knowledge about source of seized cash, you have simply avoided giving any names. This shows that you have no satisfactory explanation. What do you say? I do not remember any name who have donated the money for the trust. So even if I assume that he has taken the money for trust, he has not maintained any diary or the calculation, that means in other way, indirectly. So though it is not related, he is going to deceive the trust also because he is not maintaining the account. Please tell the average amount collected from each person toward the donation. It is about 1,500 each person collected from known people mostly. Now next page, your lordship. Question number 27. Since you say that you have collected money from mostly known people, how is it that you are not in a position to give even a few names? It is due to my present condition that I cannot remember the names. The above statement given by me is true to the best of my knowledge. Page number 36. Again, he is saying that it is true to best of my knowledge and belief, no coercion, threat, or any undue influence was brought to bear upon me in the course of recording the statement. So his state of mind was quite okay. Had there been any threat or coerce, he could have said. Now, next page 38. Question number 2. Since when you have been working in the Northeast region and in what capacity and what is your nature of job in official capacity? I have been working in the Northeastern region since 25/9/1996 as Chief General Manager Task Force Telecom Gauhati. As CGM, I am in charge of sanctioning and executing the major long distance telecommunication project mainly linked to the major telephone exchange. So he is having all this control over the giving the tender and everything. Then your lordship at page number 40. Question number 6. Please state the source of income income of you and your wife. I am drawing my salary as government servant at present at the rate of 16,000 approximately per month and is my only regular source of income. I am also having a house property income from the house building at Chennai, which is laid out. The address of the plot number so and so is given. My wife is having some interest income from the fixed deposit, etc. Next, please give me the full detail of immovable and movable property. This is there. Now I am coming to the question number 8, page number 42. My wife was serving in a Canara Bank from 1995 to 1988 and in school for another 4 years. She had her own income to invest in fixed deposit. So he himself admitted that she has own income. Now he has detached from her income. Now I am coming to the page number 43, question number 11. As per the information gathered that the cash found and seized by the police authority from your possession include sum of rupees 25 lakhs and some odd amount seized from airport on 6/9/97 and subsequently another amount of rupees so and so seized from residence at Gauhati. Please state the source of the above mentioned money. The money was collected from different person of northeastern region for spiritual and charitable trust located at Chennai. Again,
Are these answers to the question relevant for the
yes, because
instant-
he has given because X amount has been recovered. So when the CBI is going to register a case of disproportionate asset, to come to the conclusion, unfold the truth before going further, that whether these are the legal money or illegal. Maybe this is a legal money. He might, had he been shown in the income tax return, showing from where this amount has come, he has explained carefully, then it would have been a legal money. He might have taken for charitable purpose. And that is why the matter has been referred there to see whether this amount has been given in the income tax department and in the return. And from there, answer has come. He has never give this amount explained in the income tax return. Okay. There is no bar in giving and maintaining a trust. He might have taken a donation money to give in the trust for the spiritual purpose, but there should be account. There should be a detail. There should be the detail of the trust or spiritual organization. It was not there. If he have any cash amount with him, he is supposed to show in the income tax return, this X amount is meant for spiritual. However, I am having the possession, I will hand over to the organization. And he will get the confirmation that he has handed over this much of amount, X amount. And that has to be filed there.
Okay.
See, we are getting, even if from my salary, if I pay something to a charitable trust or any organization, I will get the benefit, income tax benefit I will get. I can show there, but this was never shown. That is why CBI, before coming to any conclusion, they used to refer the matter, usually in the disproportionate asset, to the income tax department.
And that
For
is
the
how
fair-
the questions are put.
Yes.
Okay,
So
I'll
income
go
tax
through it.
department goes there, they inquire into the matter and they made a questionnaire and get the answer. So similarly, there are another question 44, Your Lordship. Page number 44, question number 12. Please refer to the question number 11 and give the detail of name and address and occupation of those different person and your relation with them, and also the name and address of the said charitable trust on behalf of which you are collecting the money and the reason thereof. Answer is, at this moment, I am not in a position to give the detail of those person regarding the trust. The name of the trust is Nava Koti Durga Spiritual Charitable Trust located at Anna Nagar, Chennai. I have been authorized by chairman of the trust, Sri V.R. Gopalan, to collect on behalf of the trust the donation to the extent possible. I will try to give the detail on Monday. He could have given in the DW also once, he said, because he has made a commitment. Now question number 14.
These statements were recorded even prior to the CBI getting into the investigation. CBI investigation started only in 98. February 98. These statements were recorded according to his evidence, the IO's evidence, the IT officer's evidence, PW9 was examined. My lord, just to clarify, because it seems to be going off track. Your Lordship may only see page 32 of the evidence of PW9, where in volume 1.
Page number, what you said?
Page number 32, volume 1.
Because if you will go on giving a reply like that, it is difficult for my continuation. Your Lordship.
CBI came into the picture, then CBI referred it to income tax. That is factually incorrect. Because this income tax, what happened, my lord, as soon as the money was caught in the airport, it was flashed in the newspapers. Based on it being flashed in the newspapers, the IT department filed an application before the special judge and said, we want to inquire him. The special judge allowed the prayer of the IT department, and then IT department came and took the statement while I was in judicial custody in jail.
That is what I said. It is taken in.
When I was in jail. After the statement, IT department dropped the proceedings against me. It's admitted by the witness in the evidence.
So these actually are not relevant for the.
I'm saying
It
these
is
are not.
having an evidentiary value because FIR is on 6/9/97. This is recorded in 19/9/97.
But before CBI came in the picture.
He is the central government, employee of central government.
No, you stick to your arguments with the
Because these are
depositions and
the
evidence.
These are being exhibited. This is the part of the prosecution to prove his case.
This is exhibited by whom?
CBI.
PW that.
Yes, Your Lordship.
Okay.
That is why I have to. Because in the appeal, we have to appreciate the evidence. We have to show that these are not the legal money.
Okay, then go ahead.
So
But stick your arguments to
Yes.
the depositions and whatever happened in the trial.
This is the third theory which they have come to the trying to take in.
So
the
what you
rescue,
want to say
but
is
none
the
of
charitable trust, but they have not given any
not given.
particulars.
They could have taken in the DW, they have not taken. In defense also. As my learned friend said, the income tax department has dropped the proceeding. That also has not taken in the trial court. Now I am coming to the fourth theory. Fourth theory, what they have taken, that this amount is given to the accused person for the purchase of jewelry, diamond jewelry. So Antique Himre happened to be his friend. They have come into the close relation in the sense of friendship. And he has given money to purchase this jewelry. To that effect, I am coming to his petition, Your Lordship. I have to explain each and everything because he has come as a DW also, Himre. So this is the fourth theory they have taken in their rescue, but none of the theories they being succeeded in the trial court.
His petition or paper book?
Okay, I'm coming. Their application is there. Which they have filed an application for the release of the X amount. T.N. Khemre has filed an application before the trial court taking the plea that I have given him for purchase of the jewelry, so X amount has to be released in my favor. That was rejected. My contention is that it was during the period of somewhere 98 or application is there, I would say.
Okay, he wanted custody, but then it was rejected.
But it is rejected. And at that point of time, in their application, they have quoted the values also. So in advance, how they can quote the value? My concern is that it is a criminal case. We have to find out what is going in their mind to take the defense. In advance.
What calculated? He knows what he is buying.
Jewelry of this much amount, this much of carat. It has quoted there in application. When you have given a money for purchase of jewelry, how you can quote? Because it is a tentative amount, X and YZ.
No, not tentative, because they are all related. I'm told that.
No, he's a
the
public
one who
servant.
is involved in jewelry business is related to.
No, not at all. Not at all. Reason being, they have come into contact while they have taken the plea somewhere in the hotel or somewhere, thereby they become the friend.
No, father-in-law or somebody is that?
Father-in-law is having a jewelry shop. Then Mr. Khimre has come to know that his father is having a jewelry shop, and one fine day they have went or having some dinner. Then they have proposed that his wife liking the jewelry, so I am paying you the amount. They have taken the plea. I am coming to that petition, Your Lordship.
But what will they buy? They will know. And that is how the money was given, according to them.
But how you can quote a measurement and the value?
Because it was told by them, perhaps.
In any jewelry, only after finishing, its measurement.
It's not like
in
we
carat
going
is-
to a jewelry shop and purchasing. They know each other.
It is a
knew-
tentative. They have given the list in the petition. Calculated the amount. I am coming to that list also. It is there. 349 page.
Of paper book?
Yes. Volume 2.
1, 2.
2. It's quite strange.
What page? 349.
349.
Yes.
That the petitioner states that on receipt of the aforesaid information, the petitioner decided to procure the following diamond jewelry from father-in-law of the K. Ganesan. Para 10. The others are there. In page number 6, one pair of diamond eardrop with 24 diamond weighing about 3 carats. Beforehand, how they will come to know? Every time in jewelry, always variation is there. Even I will say that you have 10 grams or 14 grams.
But these are fixed amount. We know what jewelry.
Then if had it been, show me the catalog and the price. If it is a ready-made jewelry, then the measurement, weight and amount is quoted. Had it been not ready-made, it cannot be. They have taken this defense. I'm appreciating, but you give me the receipt and the ready-made jewelry, quoting the measurement, quoting the amount. Because we being a lady, we usually go to purchase a jewelry. Even if I purchase a ready-made, measurement is given. And if it is a diamond, it is written as a carat and everything.
No, that will come only when the purchase is made. Now he is on his way.
He have not purchased yet. He has given to purchase. Given
So
to
it's
purchase.
on the way to for purchase.
So, but the calculation may kindly be please. 8 pairs of diamond eardrop with 28 diamond of 3.5 carats. Rupees 11.2 lakhs.
The father-in-law had already told him what the amount
Without
will
paper,
be.
whether he can able to remember all these values? Humanly not possible, Your Lordship. Because diamond jewelries are always made in platinum or gold.
This is, you're showing from where? 349 is a continuation of what?
There, please.
This is the application for
Application.
custody.
Yes.
Acha, 451.
Yes. That shows how they are trying to defend. They are creating a different theory to defend them.
Okay. Then?
That document, sorry, I never interrupt, but kindly see the document at page 105, same volume. Learned friend should see the document at 105. Exact questions your lordship asked is answered.
105. Yes.
Kindly see the heading. This is the bill that was given.
Wait one second.
It's called estimate. Estimate. The following is the approximate market price of diamond for the following jewelry items. Then kindly see the note at the bottom. Even this bill, the note says, the above is the approximate cost of the diamond alone. Cost of gold and marking charges are extra. 90% advance to be arranged in cash. Delivery within. So it was an estimate. The money was given for this jewelry for the purpose of this approximate estimate.
This bill was given by the father-in-law of the
Yes,
petitioner.
and this bill was recovered by them, and this was placed before the trial court as a document.
What is the amount? What is the amount? You total the amount kindly.
Okay. 1.4.
And what is the amount recovered?
Look, several
No, please,
pieces.
please, when you are interrupting, you argue in your own
Yes,
way. I'm
but-
helping you,
but
you
if you
place
say-
that, that X amount, you give the calculation, that is all.
Look, the calculation is there on the
So
document
you,
itself.
you total it.
And this, what was given is an advance for the estimated amount. And there are 8 pieces totally. Kindly see page 349.
And in piecemeal manner, it is very difficult to
No,
argue
no,
in
I
that way.
just thought.
Because
it was-
let her finish.
I'm sorry to interrupt. I won't do it
What to
again.
do?
But
Either
I'm
you
saying-
clarify, because it is
Because-
very easy to 1, 2, 3, 4, 5, 6, and 2, 2, 2, 2. Then
No, what, here you see,
how much amount recovered?
here you see there are 8 pairs of diamond
Yes.
eardrops.
Yes,
And here the estimate is only with regard to one pair.
yes.
So you calculate it 8 pairs. So it will come to that amount, 11.2 lakhs.
So let them produce the voucher also estimated, total voucher, 29. He want to get released 29. X amount, not only this amount.
29 lakhs, right?
Yes.
Charge is only for 25 now. They dropped the 4 lakhs.
Uh-huh.
There's no charge.
That,
for-
that was available in the house.
Which was recovered totally, we said 29.
And when was it recovered? Which year?
Look,
It's a 97.
97.
So
Okay.
at that time, money value is too high at that point of time.
Acha.
So this fourth theory, they have taken in their defense
Hmm.
that this amount, X amount has been given by so and so for the purchase of jewelry.
Mm.
And I'm coming to the DW, then I will have to go by the DW.
Mm.
Well, now the question is they will have to prove the recovery of that amount, that it is a legal money. Then there is a no case. And the judgment which is given by the trial court below is quite reasoned order. There is no scope of any deviation. And even the judgment, it is said that on the different steps and during the course of trial also, he has taken the different plea, always changed his statement. That itself shows he could not able to satisfy the source of this money.
Money.
And therefore 13(1)(e) is attracted. He has to satisfy this one, Your Lordship. We have to go by old act.
Yes, 13(1)(e), okay. PC account leon. Prevention of corruption. PC act একবার।
We need to have a old one.
Old one.
Yes.
পুরোনাখানে থাকবে স্যার। Oh, yes, yes. Hmm. Yes.
13(1)(e).
Mhm.
If he or any person on his behalf is in possession or has at any time during the period of his office been in possession for which a public servant cannot satisfactorily account of pecuniary resources or property.
Wait, this is a new one, I guess.
Yes,
Wait.
your Lordship is getting the new one. It requires old because
Oh, 20 আগৰ পুৰণা আছে old hai. Old will be mentioned here. Okay, to 13(1)(e), right?
in the below,
Below,
down
yes,
below.
yes, 13(1)(e). Hmm.
If he
He-
or any person
Hmm.
on his behalf is in possession or has at any time during the period of his office been in possession for which the public servant cannot satisfactorily account of pecuniary resources or property disproportionate to his known source of income. This he has to satisfy. Explanation for the purpose of this section: known source of income means income received from any lawful source, and such receipt has been intimated in accordance with the provision of any law, rules or orders for the time being applicable to the public servant. So while public servant is in a chair, he has to disclose all source of income.
Yes.
That was not done. That was not done. So, and this case is also registered under this section. And to satisfy this section, he has created 4 theories, which I have narrated
Yes.
earlier. That somebody has given for purchase of machine. Then he has taken a money for some trust. Then he has brought one of his friend Khimre. Now, with regard to the Khimre, again we have taken the statement of the bank. At that point of time, Khimre was insolvent. They have taken one plea that he has settled his NPA account in 2001. This is a case of 97. One-time settlement is there, but it is at the time of 2001. Your Lordship will appreciate in Arunachal, the resident who are the resident of there, they did not have to pay the tax.
Yes.
So when he has come in his defense, or he is saying that he has settled the amount in 2001, it is nowhere relevant to this, because during that period, all statements are there, and the bank has said he was insolvent. In his account, there is no amount to pay X amount for the purpose of purchasing this jewelry. That is clear from
That is assumption, because
No,
you
it is
cannot
not
just-
assumption. We have taken the statement. Now, if he has taken the plea that 2001 he is a solvent, he has given a one time, where is the return? Even if you are not supposed to give a income tax, you are tax free, but you are supposed to give return and you are exempted. He said he is taking the plea, no, I was solvent in 2001. I have deposited the amount in my bank, one time settlement. Fine, he has deposited, and Vijay Bank manager has also said one-time settlement is there. In one-time settlement, they usually take the actual amount, and there is a exemption in interest and everything that is calculated by the bank. But at that point of time, from 97 onward, he was insolvent. His statement was seized. His statement was seized, and he was running in NPA. Khimre.
So Khimre was insolvent.
Insolvent.
In
He was running insolvent. NPA is there. He has taken a loan crores of rupees. And in 97, he was not in a position to pay this X amount. Maybe in 2001, he might have sold some property and he has settled one time. Usually what happened in the loan matter, if the party is having a property, to get rid of this pressure, they usually sell out the land and they settle the one time. And this one time is done at 2001. So 2001 cannot be related at 97 when his account is running in NPA. And that defense they have taken, Your Lordship. I'm coming to that document also, which they have taken the defense.
But I remember Mr. Is showing that he was actually capable of giving that money. That
Statements were filed. He entered the box. He produced the documents. He was never declared as an insolvent. Bank loan, he had defaulted, was treated as an NPA. Thereafter, the entire bank loan, entire amount of 1 crore, because, my lord, the trial court, may have only 1 minute, my lord, just to refresh. This theory of, my lord, the construction company, all that, my lord, was a theory that they wanted to, based on my FIR, confession was recorded and reduced into FIR. In that confession and FIR, the allegation was, and the charges were, that this is bribe money. Then they investigated. They could not find any bribe money. Then, my lord, they started creating all this theory, Prajudosh, construction. My case is very simple. This is a money given to me in a fiduciary relationship by Mr. Kirme. And this is the money I'm taking to give to my father-in-law for the purchase of jewelry for Mr. Kirme and his wife. That is my only theory. That is my only theory.
But according to her, you have changed your.
Malad, this is all based on the alleged confession FIR and the investigation and statements under 161, which is irrelevant at this stage.
How it is
In
irrelevant?
trial court, what was the evidence? What was the charge framed against me? And what was the evidence let in? Initially, since my learned friend, we are not supposed to speak about matters during investigation, but since my learned friend said this, I have to open up and speak about it. The charge was that you were caught with this bribe money. You confessed before the district magistrate that this is bribe money, and based on which you were remanded. Then they did extensive investigation. They could not find any bribe money. Matters then, without a proper consent, transferred to CBI. CBI also registers as bribe. CBI registers, they also completely investigate. Finally, they find that there is no bribe money. In the meantime, when CBI was investigating itself, Mr. Kirmi went before the CBI and went before the court and filed an affidavit in court.
But you complete it.
He went before the court and he said, this is my money, which I have given. I have income. I have this money with me because I have a hotel business and I have formal business. I'm a solvent person. And he filed an application asking for return of this money. They said investigation is pending, wait. Then he filed a revision before the Honorable High Court. High Court also said matter is pending investigation. And therefore, once the charge sheet was filed and once the charges were framed, at the time of framing charges, they dropped section 7 and only framed charges under 13(1)(e) for being in possession of disproportionate assets to your known source of income. So what do I have to do once the charges are framed? I have to satisfactorily explain before the court that this income I have held in a fiduciary relationship on behalf of somebody else. If I had claimed this money as mine, then my learned senior is right. Then income tax, where did you reflect it in the income tax? Did you reflect it in other before the authorities? All those questions will arise. But my case from day one before the trial court is that this money does not belong to me personally. I'm only holding it in a fiduciary relationship. I'm carrying it to Chennai, to my father-in-law's house, and handing it over to him, for which I produced the bills.
During the trial, there was no change in your stand, right?
No stand. Only one stand, DW1. DW1 enters the box. Mr. Kirme entered the box. And he says, and he produces.
I'll call you when required. Okay.
Sorry, ma'am.
Let her.
Yeah. So, my stand is this. You are relying on materials during investigation, which is not even part of the charges, which is not even part of the trial. The trial was simply 13(1)(e). How do you satisfactorily explain? Then I too satisfactorily explain, my lord, if I made these statements and Mr. Kirmi did not enter the box and did not produce the relevant documents, all this is fine. The only reason Kirmi's evidence was discarded by the learned trial court is two reasons. One is you had defaulted in your bank loan. Then Mr. Kirmi and the bank manager admits in his evidence, though there was a default, entire amount was paid as a one-time.
But that was in 2001.
By the time the loan amount ballooned, he said, I have the money, I'm paying it. As a businessman.
But in 1997, your account was an NP account.
One account, my lord. One account. Because I have businesses, other businesses. I have hotel business. I am sawmill. My lord, sometimes as businessmen, they allow the account to become an NPA and then they pay it. It's for their business reasons. But the trial court says that since your account became an NPA, therefore you don't have money. It is like a reverse googly there. Since you did not became an NPA, you don't have money. But the learned trial judge failed to see the evidence of the bank managers who said one-time settlement, entire amount was paid in one shot of 1 crore and odd. Even in 2001, 1 crore and odd was. Second, my lord, sorry, my lord, I'll just complete, then I won't trouble this one. Second is that you had negligible balance in your account. So Mr. Kirmi says, I'm a businessman. I constantly transact money. Please see, you're only seeing the balance, but see the transactional values. See the transactional amounts. it runs into several lakhs. Therefore, the trial court only picks that portion of it and says, since you had a negligible bank account, bank balance, therefore Kirmi could not have given the money. Only on these two grounds, Kirmi's evidence was discarded and I was convicted. It's as simple as that, Madam.
Okay.
I'm grateful.
No, what has happened is, had it been heard at one go, I would have remembered, because now I've forgotten.
No, it
So
is,
in
for
between,
me
you
also
have
it
to
is
interrupt.
difficult. My total sequence has been.
It's okay, you keep
How
on
can
doing,
I-
and you
how can
also
I-
submit a written argument, because again, I'll forget. I'll not deliver the judgment today. I'll have to again go through.
In any case, it is not possible to.
Not
because
possible.
That is why I wanted to go by the judgment. In judgment, it is very nicely
No,
appreciated.
but then judgment, we don't
Because
read.
the appreciation of evidence is there in the judgment.
It is,
There is a change of
that
statement.
court who had appreciated. So
There
we
is
will
a change of
appreciate it
statement.
separately.
There is a
Mm.
change of statement.
Mm. But then in the trial, he's saying that there is no change.
But
During
131
investigation, okay.
131 in the IT Act, it is having a evidentiary value. That has been produced in the trial court, exhibited also.
But
How
how
it can
far?
be discarded?
No, how far it has an evidentiary value? Do you have any judgments, or show me
Then I
131
will
of IT Act?
day. I will bring other day. Let it continue then. Day to day hearing, let it continue. I am ready to argue. Because when they have taken the time.
You finish
again,
as far as possible, then whatever is required, you bring
we
it
have
on
to
the
go
next
by
day.
DW also. And then in the judgment, it is very nicely, all the evidence has very nicely appreciated. And in fact, in the judgment, trial court judgment, it said, in every step, he has changed his statement. That has
No,
been
why
taken
we
into
don't
account.
go to the trial court judgment is that will create a biasness, I mean, towards. So we will appreciate it separately. We will deal with the evidence independently. Okay. So you go on, you carry on, and if you have not prepared your written argument, right?
Because I have to go by this only. No.
You prepare it and give it to me
Then I'll prepare. What
as
to do?
small
Now
as possible.
I've lost my sequence.
No, you must have made a note. Go by that.
But it was coming by sequence. But I have lost my sequence, and he has successfully, he is successful to get rid of my this sequence.
No,
So
no,
this is
you
my
will
sequence
not
also.
lose your sequence.
No, but not supposed to say in the middle because he has come.
No, the court has also allowed, because I forgot the.
I would have given him time. I would have not started because now what happened, whatever I said, he will go on searching and other day he will start the argument. That would not be the process, your lords.
No, he will not again do. You can continue.
But now it is not possible on my part.
You'll do it some other day or what?
I will have to start with again from, because I have to show, this is settlement is 27/3/2001. And I will have to show the statement.
No, that is settled, that he had settled it long after. That was at 97, but then he said he has other money. It's okay. That I'll think over and consider.
Now there is also with regard to the sanction, DSP Act. All these are there.
What he's saying is that the
with regard to the fiduciary relation and with regard to the sanction, with regard to the DSP Act, I have to explain because these three important things he has taken. And now with regard to all the judgment, how it is, all these judgments are relevant to him.
Some other day.
No, I will do how, as your lordship feel.
No, no,
I have to abide by the court.
Hearing
if your lordship say I will have to continue, I will continue. If other day, I am ready to do other day.
No, you
It is
continue to
totally
whatever extent you can.
When I have submitted before your lordship, I will have to continue. But if your lordship,
You will not lose your track. You see the note and you continue.
Otherwise, also sequence get destroyed. I am coming to page number 339, your lordship.
Page number
339.
Yes.
Volume 2.
Yes, this is what?
This is
Vijay Bank.
from the Vijay Bank. With reference to the above, we are pleased to inform you that as per the latest guideline of the RBI in respect of one-time settlement of NPA, on account, the party has cleared outstanding balance in the account. Kindly note that our claim in respect of decree issued by you in your favor dated so and so, 11/1/2001 and 6/2/2000.
So 2001, it was cleared.
Yes. 2001. So degree was there because of the NPA.
Much
So
after. the-
much after.
Mm.
Much after. So where now the question is, they are saying they are insolvent, but admitting also they are NPA, and this paper itself shows that they are NPA. What I mean to say. So at that point of time, in the year 97, they are not so much of solvent to pay an X amount. It's a quite huge amount. However, they have filed a petition before the trial court for the release of the said amount. Thereafter, all they are sitting mum. No application filed in the appellate court for the release against the rejection of that one. They never come here because the amount is not less. At that
24
point
lakhs,
of
right?
time. Had they invested this amount after getting it released, it might have been doubled because it is of 97. It is more than 25 years. But they never agitated in the High Court or anywhere, or refiling there, that after the completion of the trial, at least this amount, X amount has to be released. That so something wrong is there. Had it be genuine money, they could have asked, because he was running in NPA. He was in very much need of that money. He cannot sit silent because he have to pay that. And moreover, he has paid that amount in one time, or he has paid this X amount for the jewelry. They are tax-free. Reason, whether he has given any return, filing return, statement. Answer is no. In defense also, DW, he's taking that I was solvent. During the business, NPA usually happened, but where is the income tax return filed? That he has got exemption of so and so amount, so and so amount.
Yes.
Income tax is exempted, but they are supposed to give return. That is mandatory. Everyone has to keep a file showing the return. Only tax is free. He could have given in the DW. They have never given. They could not able to satisfy the source of this amount, X amount, neither Khirme nor the accused. Had it been a genuine amount, or had Khimre has given genuinely to purchase a jewelry, he could have shown the income tax return file.
Okay. That has gone into then. Yes. Then
Page number 171, PW 67.
of the same paper book.
Yes, yes, it is. Volume 1.
Paper book 1
Yes.
or 2.
1.
Page number 171.
171.
Yes. Yes. This is whose statement?
CBI inspector's statement. Page number 172, paragraph number 2. I am coming to the relevant portion. In fact, Abid Hussain has also given his statement. Prior to the investigation, K. Ganesan himself disclosed before the IO and other authorities at the airport, while the money was seized, that the said amount was received by him from M.K. Agarwala, Fulkan Datta, Maheshwari, and Abed Hussain and Mohammad Ghiasuddin Ahmed. During the investigation, it was found that Bogaigaon Concrete Industry under management of M.K. Agarwala and Mr. Maheshwari was a partnership firm, and Fulkan Datta, an employee of Assam Concrete Industries, work order for supply of concrete hume pipe to be purchased by task force. Mr. Abed Hussain and Ms. Muhammad G. Ahmed were given a work order for laying out the optical.
These are statements taken during the investigation. Unless you will show
but
contradictions.
This is the evidence before the trial.
But then those will be relevant only in cases of contradictions and all. But then this will not.
So they have got the opportunity to cross-examine and contradict it. They cannot
Where
able
is the
to
contradiction? Show me the contradiction before the police.
There is no contradiction.
Then why will we go into these statements? The statements given during the investigation.
This is the evidence, Your Lordship. Taken before the
Yes, evidence, but then
we have
he is talking about the statements given in the investigation. Those will not be relevant now. Unless this witness is contradicted.
But here he is an IO.
What he has stated from his own.
They are saying that IO has very perfunctory way investigated this issue. So IO has already deposed.
Now we are no longer in investigation. Forget that.
But we have
now
to,
what are his statements before the court?
The evidence, because this is appeal. In the appeal, we have to appreciate the investigation, Your Lordship.
I don't know what you're talking about, but investigation, the whatever statements are stated before police release is not relevant.
These are the evidence taken by the trial court.
No, what are his statement before the trial court? What was investigated, what was recorded, that will not be relevant. Because 161 papers are waste papers. During the trial, when it when the trial is conducted.
160.
Only for the purpose of contradiction.
So after deposition before the magistrate, it has a values.
164, okay. 164 confession.
I'm not telling about 164. Evidence of the PWs. To testify
Statement of the witnesses.
The truth.
Statement of witnesses.
Statement of the witness.
Under 164.
No, Lordship. Before the magistrate court, evidence, PWs, prosecution witness.
Before the trial court.
Before the trial court. That is having a evidence.
That is relevant, but what
this
he
is,
had
this
said.
is 161. This is the evidence before the trial court.
This is what he is the police officer.
Yes, Your Lord. IO, investigating agency.
Okay.
He is testifying that my investigation is correct. Before the magistrate, before the special judge. This is not.
No, what police officer says during his investigation, yes, IO, that we don't go into much. Only to show the contradictions of other PWs. Other PWs, that would be relevant.
He is also PWs.
He is a PW. He is a final PW.
There are two IOs.
Two IOs, right?
Yes, there are two IOs.
So what he had done during investigation is okay. He has investigated.
Has to testify there. His investigation is fair.
No, he had done his investigation, submitted charge sheet.
Stigma that investigation is not fair. What I mean to say, investigation is fair. It has rightly been done. And he has deposed before the special judge, and you have been given.
Whether he has taken investigation is not fair.
Yes, just now he has said it is a table work.
Investigation, as far as, of course, subject to correction, investigation they submit charge sheet, and the end of the matter. When they come before the court, their statements will have to be.
So these are PW's statement.
Yes, but then what we have done in the investigation, forget it. Now we will have to see whether
we have
witnesses.
Witnesses.
PWs, no, the witness prosecution, I'm not talking about official witnesses. The witnesses, if their statements are contradicted, then we go into that police's statement. Of course, he will defend his investigation.
So they will get opportunity for cross-examination to contradict also.
Where is cross-examination?
They cannot able to succeed, to contradict.
Okay. Let's show me the cross-examination, further examination in chief.
And now come to the, Lordship, this is the cross-examination at page 190. Again,
These are all. So we will come to the statement of the police later. What are your
he is
have you
also
been able
prosecution
to
witness.
contradict the witnesses, the prosecution witnesses, not official?
All they are prosecution witness. IU is prosecution, very important witness.
IU is always prosecution witness, but he is the official witness.
They are other from, I am coming to that. From 13 to onward, they are all bank official. So I am not going by them. They identified only the money that it is from their bank. But who has taken, they can't remember. Naturally, who has taken, they can't remember. So they are bank officials' statement. I am not on that. Now, barring them, one Abid Hussain is also there. I am coming to that also. 163, your lordship. Means bribe is a thing we it is always given in a hidden way. So they said it is not a bribe amount. Bribe cannot be given openly. And is there any, when there is a recovery of amount, you have to prove, or it is a presumed that it is a bribe amount, unless you can able to prove it.
Unless they rebut it.
Rebutted. That unless they can able to prove that it is a legal money.
Okay, then
Bribe cannot be fetched in the open.
Okay, 163.
Then this is the evidence.
Who is
This-
Abid Hussain?
Abid Hussain. I am the resident of Hidayatpur since my birth. I did my graduation. I know, second para, I know K.R. Ganesan. I can identify him if shown to me. Although I did not meet him personally, for the work undertaken by me in the More area, the director telecom was the competent authority to pass my bills. The name of the said director was Mr. Khan. His office was situated at Chenikuti, Gauhati. As far I know, K.R. Ganesan was posted as the Chief General Manager, although I do not know whether K.R. Ganesan was involved in the passing of my bill. I know the accused K.R. Ganesan was caught at Bojar Airport with a huge amount of cash money. This I read in the newspaper. I do not know whether my bills for the contract work are routed through accused K.R. Ganesan. At this stage, he has been declared hostile. Now, so when he become hostile, usually prosecution cross-examine. It is correct that my statement was recorded by Mr. Dasgupta, IO of this case of police station. My 161 CRPC statement is Exhibit 64. It is not a fact that my contract bill were pending with the accused K.R. Ganesan while he was posted at CGM Task Force in Telecom Department in 1996. Confronted with the portion A to A Exhibit 64. We have to then take the 161 that has been confronted because he become hostile. Why he become hostile?
He had denied the statement made before the police.
It is not a fact that I...
So hostile statement, you know that only those straight statements supporting
Yes.
the prosecution will be relevant, otherwise it will not be.
Which is relevant.
So what are these straight statements? Nothing, only that his exhibition, examination in chief. So this will not come in any
I have
rescue.
confronted with the portion B to the B Exhibit 64. So we have exhibited 164. And that has been also 164. Exhibit 164 has also been exhibited by IOs also. That he has taken. On oath it is recorded. So he has become hostile here. That has been again, IO has supported it. On oath in the court, he has said that he has become hostile. In fact, he has given the bribe. That is the procedure, Your Lordship.
According to you, this Abid Hussain has given the bribe.
He has now become hostile.
No, he became hostile.
But his 161 is there, Your Lordship.
His 161 will not matter.
We have exhibited it.
So what? Even if you exhibit 161, how will
is
it
having
matter?
Evidence.
No, this is
can
not
bring,
law.
I can bring the judgment
Why?
also to that.
This is not a law. What 161 exhibited and it will become
No,
relevant?
no. Which portion he has contradicted?
Contradicted before the trial court.
Yes, 161. The statement which he has given to the IO, he has become hostile.
So he is denying
so
that it's not a fact that I have stated.
Yes. So at that point of time, usually prosecution said, look here, you have said this and this and this before the IO. He
Which
will
he
deny.
denied.
So at that point of
So
time,
finish.
no, at that point of time, usually we exhibit it.
So what is
I
the
think
purpose
Mr.
of
Bilal Kamar
exhibiting
is
161?
Diyal Kumar is not here because he is also in the prosecution. He can well able to.
Even Mr. Kamar will say that exhibiting 161 will have no value.
Here, what we mean to say, when a person become hostile, so to disprove that he has become hostile, he has also changed his statement. And
That is why he is hostile. He is denying
his statement. So we are relying on that. So we can draw a presumption.
No presumption.
We can draw a
You
presumption.
don't know.
That's it. I will bring the judgment, your lordship.
Even if the judgment is there, I'll not believe. 161 cannot be relied on. At best, 161 will be produced.
Never be relied on. That is why it is testified in the court by calling the PWs. But when a person become a hostile, at that point of time, prosecution, when I was also there, we usually exhibit it. And at the time of argument, we say that so and so has become hostile. His 161 has been exhibited. Though at that point of time, he will say, it is not a fact that I have stated so and so.
So, okay, exhibition, you can exhibit.
Sequence,
you can exhibit.
No, to bring the chain. Yes, this was the story.
But then the story, you can exhibit 161. Yes. But the story projected in 161 will not be believed.
That is a different issue. But to say that the IO has done his investigation fairly, we have to do it because the allegation is that it is a desk work.
See, why this 161 is not believed? Because in our country,
yes,
even police officers are not believed.
Yes, that
is why 161
is testified in the court. And when there is a when the prosecution become hostile, at that point of time, usually 161, we do exhibit from this portion to this portion, he become hostile, and from this portion to this portion, he has admitted.
Even in inverted comma, we put it.
Yes. It is there. For that
But
purpose,
what benefit he will get from his statement?
For the presumption, for the purpose of presumption, for evidentiary value, I can show your lordship that. To that effect, I can bring the judgment also.
You can bring judgment showing that 161 can be exhibited, but what advantage, what benefit you will get it from here?
To draw the presumption.
What presumption? The criminal case will lie on presumptions.
Along with the other circumstances. Along with the other circumstances.
There will have to be a chain of circumstances.
Yes,
right.
He's trying to prove that this is a legal money.
But chain of circumstance has to be with respect to the fact, established fact.
Yes, established fact.
It cannot be on presumption.
We cannot broke this chain. For that purpose, we have to draw this presumption. We have to show, yes, investigation is not perfunctory. What I mean to say,
investigation, whether it's perfunctory, whether it's not will not be relevant here. Now that the trial is over, you show the statements recorded before the trial court.
I will produce that also. I am coming to the DW then, you know, instead of wasting the further time, DWS.
How long will you take?
It will take time. It's a DW. I have to big DWs.
You don't have to read all DWs, but
then
you point out
to the
what
conclusion. It is there. Relevant things are there. It will take time.
You need not read DWs. You just have to point out what relevancy it has.
I could not able to connect unless and until I will go through. How now. And unless and until it will be read in sequence, It cannot be, we cannot make out.
You
that.
do one thing, you prepare a written argument. That will shorten your thing. Right. And then you don't have to read each.
Then
If
I'm
we
coming
keep
to
on
the
reading
relevant-
these paper
no,
books.
No, relevant portion only. Relevant portion only. At page number 192, Your Lordship.
192.
92.
192. DW1, he's Khirme.
Yes.
He has already read this. What portion you want to rely on?
One 193.
Hmm.
It is here. I have to go by all.
Hmm.
Exhibit C, under objection being photocopy, is the allotment letter of timber.
Where is that exhibit C?
Is the first page.
193.
Yes, Your Lords. 192.
Acha.
The hotel which I am managing, it is a 3-star category hotel since 1975, 1976. I was having a timber business in the name of MS Rupa Veneer and Sawmill, but the mill was established in the year 1982 and the timber was sawn in different sizes and sold and transported to the other part of, more particularly to Gujarat and so and so. Exhibit C under objection, being a photocopy, is a allotment letter of timber, is the relevant paragraph number 60,000 CFT of timber so and so, the aforesaid sawmill.
From here, what do you want to show? He is having all these businesses.
He's having a businesses. The allotment letter which he has shown, that is also a photocopy. He is supposed to give the original. By this, he wanted to mean that he was insolvent during the said period.
He was solvent.
Solvent during that relevant period. He wanted to show by showing this photocopy.
He has enough money and he can part with
Yes,
some.
yes. Yes, Your Lordship. And thereafter, page 193, apart from my regular timber business, I was government supplier and MES contractor. I know Sri K. Ganesan, who is present in the court today. I came to know Ganesan as he came to my hotel to have a lunch somewhere in the year 1996-97. I do not have any official relationship with Mr. K. Ganesan, but I shared a very cordial personal relationship and gradually it developed into a family friendship. As we were sharing the family relationship, so whenever I, along with my family, come to Gauhati, we used to meet the Ganesan and his family member. I met K. Ganesan and his wife together for the last time somewhere in the month of September 97, wherein my wife was also present along with him. During the meeting, my wife saw diamond jewelry's ornament owned by wife Mr. K. Ganesan, and so my wife also interested to purchase the such type of diamond jewelry. And during our conversation, wife of Mr. K. Ganesan informed that her father having diamond business and shop also at Chennai, and we can purchase it from her father, through her. She informed us that she will go to Chennai and she would talk with her father, and thereafter she would inform us the price of that said estimated jewelry by quotation estimated. Accordingly, she sent a quotation of rupees so and so. 90% of the estimated price was to be paid in advance in cash and delivery.
That is how they got the quotations.
Yes, yes, said. And that is with regard to the, again in page number, Bijaya Bank, he said that he has paid one-time settlement. That is in 2001. And he was NPA during that relevant period. And the bank, now, evidence of the PWs are there that he was bankrupt at that point of time when he has paid a X amount. That I will have to go through and I will have to read, Your Lordship. Now, during the cross-examination, page 195, important. I agree to the fact that Honorable Supreme Court banned the timber cutting so far. As I remember, it was in the year 96-97. He has admitted. So there was no business of timber. I also agree that a sawmill or veneer mill is generally opened in the reserved forest at the government permission. I have not produced any document to show that Rupa Veneer and sawmill was opened and functioning at the permission of the government. He is taking the plea of his insolvency because of this business. Exhibit C and Exhibit D are both the photocopies and not the original. So far as I recollect, it may be in my house. It is not a fact that I do not possess any original document. It is not a fact that the Rupa veneer and sawmill was never in existence. And I never had any business transaction from the said sawmill. He has not produced any document in original because license is also required. Trade license is also required. If you make any state cross-border transaction is there, that permit is also required. He could not able to produce. And he is admitting there is a no timber business. And it was banned by the Supreme Court.
Yes.
I have not exhibited any statement of account of my two bank account. The original were sent to the CBI. It is not a fact that I am deposed falsely and I have not submitted anything to CBI. As I already got the summon from the court, I knew that I was coming to the court for giving evidence. So it is in his knowledge he is coming for evidence. He is supposed to bring all the document. The operation of the aforesaid account were stopped in the year 1997. He himself admitted. After getting the summon, I have not gone to the CBI Rangpara and UCO Bank Rangpara asking for certificate in regard to the maintenance of account in this bank till 97. It is not a fact that I never had any account in the aforesaid two bank at any point of time, and today I have deposed falsely in regard to my bank transaction with these two bank. As on 4/9/97, I was having accountant UCO Rangapara, CBI Rangapara, SBI Bomdila and Vijay Bank, Itanagar. Apart from this bank, I did not have any account at any other bank at Gauhati or Calcutta or any other place.
So his account in Vijaya Bank was made an NPA. But he has accounts in other banks also.
UCO is also there.
Rangap SBI is there.
PWs are there, they said. I'm coming to that also. I do not know the full name of Mr. K. Ganesan. If he is handing over such a big amount to a person having a fiduciary relation, admittedly, he do not know the name. And in 97, parting with such a X amount, such a big amount, without knowing the name, without any paper, it is not a believable story. If he is so solvent, he could have gone to Chennai and he could have purchased the jewelry. At that point of time, air ticket is not so high. I do not know the full name of Mr. K. Ganesan, as I only used to call him as Ganesh. It is a fact that I have given him rupees 29 lakhs to Mr. K. Ganesh. I have full faith on him, and whenever I used to come to Gauhati, I meet him. I had no opportunity in asking about the full name of Mr. K. Ganesh. He has said he has a family relation. Most of the time he used to meet, but he did not have opportunity to ask the name. So far as I know, Mr. Ganesh has his wife who was housewife, his son and his daughter. I have never inquired from Mr. Ganesan about his native place. He has parted with money without knowing his native place. I did not ask Mr. Ganesh about his native place as he was supposed to take me to his native house. But I have never went as I did not have time to go. I never any opportunity to meet the father-in-law of Mr. Ganesh. I had a friendship with Mr. Ganesh for only 1 year. I simply accepted the version of wife of Mr. Ganesh that her father was jewelry. I never inquired myself regarding the business of father-in-law of Mr. K. Ganesan. So he has parted money without having any inquiry and testifying the genuinity. Even the name, even the address of the shop. This story cannot be believed. Now next page, Your Lordship. It will start disbursement of loan. There was a departmental proceeding against my wife. I am coming to this. I do not remember whether CBI registered a case against my wife and some official of Vijaya Bank. This is very important. in page 195 itself, last para.
Yes.
My wife, Srimati Anila Khirme, was also an earning member. At the relevant point of time, my wife was on leave as she was transferred to a place where she did not join. When I opted for the loan for Bomdila Hotel, the person who stand for my personal guarantor were Mr. Mani Kumar Subba, Srimati Karma Kanu, and Srimati Premdas Rai, and Sri Mania Taba, and my wife too. I do not remember whether CBI registered a case against my wife and some officials of Vijay Bank for illegal disbursement of loan to me. There was a departmental proceeding against my wife on 6/9/97. I was at Delhi. So all these are going on against the Khirve. So he cannot able to show the source of income of his wife also for the purchase of jewelry. Next paragraph 196. It is true that I, being a businessman, was having a habit of traveling when on 6/9/97 my friend K. Ganesh was caught in the airport. I was not there. I have never written down the currency number or currencies of rupees 29 lakhs when I handed over the same to Mr. Ganesh. So far as I remember, I handed over 29 lakhs for denomination of rupees 1000 and rupees 500. And the recovery is different. That is not of this denomination. We have to match with the recovery and the bundle upon which deposed by the bank official. This is very important. Had it been 1,500, there would have been recovery of the same amount. At least number may not be matching. But this should be matching 1,500. But the denomination I am coming, it is different, 100 and something else.
Yes.
I cannot say that money seized in the airport is the same money that I have given to Mr. K. Ganesan for purchasing the jewelry, as I was not in the airport at the time of seizing the money in the airport. I have not seen the money in the court today. I have gone through the order. It is a fact that the petition that was filed by was dismissed by the court exhibit 24 is the said order.
This is that custody order.
Yes. It is not a fact that I never given any money to Mr. Ganesh. I was not told by Mr. Ganesh that his statement was recorded by income tax officer after seizure of money from the airport. This is also revealing. These are all on oath, Your Lordship. I do not know, as I was not there during the seizure, what were the other documents were seized along with the money. Exhibit 23 by 18 is the money received that was prepared in the house of Mr. K. Ganesh. I was present when it was prepared. The financial condition of Hotel Bomdila was bad. He himself said financial condition was bad. However, timber business was good. This is total lie because at that point of time, Supreme Court has banned the timber business. It is not a fact that no timber was going on. This is very important because Supreme Court order is there. At that point of time, it was totally banned. I cannot say whether 90% of 33.2 lakhs is rupees 29 lakhs. I do not know any person in the name of Firoz Jahan, but I know a person by name Nizamul Haq. I cannot remember today. How can I know him? Mr. Ganesh never told me that when the money was found in the airport, the same were found in the envelope in the name of Firoz Jahan and Nizamul Haq. Because in the envelope, the person who has given or whatever it is written in the name of Firoz Jahan and Nizamul Haq.
Envelope had their names.
Yes. Had I known Mr. Ganesh was a big trouble, I would have helped him out. But he was never told me in this regard. He told me about this matter after about a month. It is not a fact that Exhibit 23 and 18 was prepared subsequently after 4/9/97. It is not a fact that the money that was seized from Mr. K. Ganesh at the airport was not the money that I have given to Mr. K. Ganesh. It is not a fact that money for one-time settlement of my loan was given by Mr. K. Ganesh only on the condition that I will help him in the case. It was not a fact that to save Mr. Ganesh from this case, I have deposed falsely in the court today. I have
Yes.
not exhibited any copy to show the order passed by the Honorable Guwahati High Court.
Okay. So what you mean to say is his story is not believable,
this is
and
made-
he had
made up
very
story.
bad business.
Yes.
He would not
He
have been
himself
able to-
admitted,
Yes.
and the timber business has been banned at that point of time. Some departmental inquiry is also going against his wife.
No, that was perhaps because she did not go and join in her transferred place.
Maybe we do not know the record.
Mm.
He could have produced in defense. His wife may come.
Whatever, that will not be
But
relevant.
when the DW opportunity has been given to you in your defense, you are supposed to give your 100% for defense.
Only to the extent that whether he would have been, he would have lent the money to the petitioner. That part is the issue here.
But so far, no further petition has been filed after rejection of that X amount. He
never claimed that amount. After trial, what
after
happens?
trial also, and after rejection also, he has the opportunity.
Because no, that time they were held guilty, right? So money will be forfeited.
No, it will remain there.
No, that
It
will be
could have been
forfeited.
given in Jimma.
No, Jimma, during the pendency of the trial.
He
When the
could have
trial is
come.
over.
No, he could have come for release of the same. Once it is rejected there, he could have come in the High Court.
No, he came to the High Court, he filed revision. But then that was not again allowed by the High Court.
But thereafter, he could have come. It is a huge amount.
For him, it is not.
That is
Okay. Then?
that is a story, Your Lordship.
Mm. So, what else?
Then again, this is DW2.
Mm.
He has brought the Vijay Bank. Vijay Bank. Vijay
Uh-huh.
Bank.
He
And
had
there was an
read this.
inquiry going in the Vijay Bank also. So Vijay Bank, had there been,
So he had issued a certificate after the loan
Yes.
was.
he is not supposed to come as a DW.
Mm.
But here he has come as a DW because
Only to show that he this
No, because-
NPA
because the-
was cleared.
court has called him as a court witness. Court has called him as a court witness.
No, he is the DW here.
DW.
Mm.
Because on the behest of the accused, he has come.
Ah, he is the
Yes,
accused
we support
witness.
him. Yes, support him.
Mm.
But at that point of time, there was certain inquiry going on in the bank also. Because of the
Okay.
disbursement of the loan.
Ah.
There is certain irregularities in the disbursement of the loan.
No, he was brought only to the fact that he had cleared the loan amount. Only to that extent. 2001.
But he is supposed to come as a CW, Your Lordship.
It's okay. He was brought by him, brought by the accused person. To show that he is not insolvent anymore.
I am coming to that, Your Lordship.
Okay.
Today I have appeared before the court, receiving the summons from so-and-so. During the year 2021, I was working as a chief manager, Vijay Bank, Itanagar. I remember it well that the case for recovery of loan was a file against hotel bomb dealer. This shows that NPA, that is why recovery has been filed. Mr. N.T. Khimre at DRT. DRT is there, case is there. Only because when there is a NPA, then DRT will be there. Case would be there. So NPA is there. At that point of time, he cannot able to give this X amount. Had he has the X amount, he could have cleared the amount in the DRT. Recovery certificate has been issued against him.
No, he was not able to. That is why at 2001 he gave it.
What I mean to say, at that point of time, he could able to give 29 for jewelry, but he could not able to satisfy this loan amount. And he has awarded with the recovery certificate. This is more priority than jewelry.
Okay.
So what I mean to say, the accused has trying to take the benefit being a friend. As my learned brother said, in the fiduciary capacity, they have certain understanding. He bring him in his defense.
So what you mean to say is 29 lakhs instead of
Yes,
giving
he
it for
don't have
purchasing.
capacity to pay.
Instead of giving it for purchasing diamonds,
Yes,
he should have cleared his
he
loan.
would have paid here.
Mm.
Because this is a matter of record. Official record. Public document.
His wife wanted it and he gave that as a priority. He will leave everything. Then present to wife.
He is ready to go for DRT certificate.
Ah.
He is ready to go to jail to satisfy the wife.
There are some people who doesn't care about court cases. Yes. Then
So cross-examination part is also there. Should I go, Your Lordship?
no, it's okay. Very enough. I've already gone through.
No.
One-time settlement and all. I have not seen the RBI circular.
Then I am coming to 200, Your Lord, page number 200. This
This
is
is CW1.
yes.
Hmm.
This is a court witness.
Who is he? CW1?
Some V. Chandu.
CBI. He is a CBI person.
Yes.
Hmm.
He has recorded the this 164. 164. It is there. I am coming to the cross examination instead of going to the here. He has proved this charge sheet also, and these are the paragraph after seeing exhibits 4.
Okay, we will stop at 4, huh? Because I have some other hearing matters. That 1 hour I'll take it. Then we'll again restart when? Tomorrow. Tomorrow is a motion day.
As your lordship pleases, I am here.
You need not come to this court again. Let her finish. She will take some time, I think.
He may argue. Like today, he has started his argument.
So we will again continue day after tomorrow. But make it precise, make it short, and give your written argument.
Okay, I will then come with the written. Then kindly make it.
Okay, then what you want to show from 200?
Oh, yes. After seeing exhibit 4, I state that the said document was a question mark document and it was sent to the GQD by my predecessor, IO, for his examination and opinion. But the said opinion is not listed document, and as such, I cannot say even after going through the case diary that what is the opinion. Next para, I have stated in my charge sheet at page 3, Abid Hussain made a judicial confession.
Exhibit 4 was that, no? Right, this Exhibit 4 was what you had placed?
The document, money receipt.
Money receipt, yes.
To whom it
That
may
was
come.
sent as a question document.
Then, with regard to 164, I have stated in my charge sheet at page 3 that Abid Hussain made a judicial confession before the magistrate, and his statement was recorded by CGM on 18/9/97 as confessional statement recorded under section 164 CRPC, and the same has been shown as document number 35.
Abid Hussain is an accused.
No.
So then what confessional statement? Statement.
He become hostile. And he has already given his 164 statement before the CGM. So that is having
that is a statement. It cannot be a confessional statement. He is just a witness. Statement, it's okay. 164 statement.
What is the value of 164? Since you are there.
Until and unless it is not brought into the record from the oral statement, it cannot be a substantive evidence.
It cannot be a substantive.
Clearly marking the document also will not be a conclusive proof of
that is what I am saying.
164, it is taken before the CGM. By CGM.
Matter.
It is having a evidentiary value.
No. That is what I was telling you.
Everybody knows.
It is a settled position.
But it is having a evidentiary value. May not
it
be.
Is having a value only during investigation.
During the investigation.
When the trial comes, it is to be recorded and translated into evidence, and that will become the substantive evidence. That can be looked into.
Only statement before the trial court will be substantive evidence.
Yes.
No 161, 164.
I am not on that. But 164 in the trial court, it is having a values.
You are saying both ways. I'm not trying to say that. Again, you are saying 164. It's okay. You carry on.
Then I am coming to. Then 313. It's a long one. 313.
313. What he had denied.
313. Yes.
He had said that money.
Lordship has said that he has not, he has given one statement with regard to the T. Khimre, and before the IO, he has changed the statement. But in 313 also, he has changed the statement. Questionnaire has been given by the special judge CBI in 313. That I will have to go through, your lordship.
No, no, we'll go through
He has
only the
changed
answers.
he has, yes, answers. I'm going through the answer, his answer.
Granting sanction for prosecution is simply okay. Then on being completely denied, I never stated any such thing.
Question number 2 and its answer. Question number 2 and its answer. Then question number 10, your lordship. I have to go through. There are so many are there which shows the relevance.
Go through the answers.
So many is
It being completely
because 313 is a very big statement. Question number 2.
No, this is carrying cash by, it's not an offense.
When I asked you to open the bag, you have informed so and so. The answer is, yeah, big bag was with for which you were not in a position to open. The same small bag contains rupees so and so, and the same carried by you to purchase the same some machinery equipment of so and so.
What
His
answer you are
is
reading?
that it
Which
being
answer?
a completely false, hence I deny the same. He is denying everything.
You have said that there is a change of stand. Where is that?
Then question number 10.
10.
The question has been put, donation with regard to the donation of trust in Chennai.
He examined me by almost judicial custody when I was under tremendous mental pressure and trauma, and not in a problem. I was forced to put my signature. He came to examine me for income tax purpose and not for cash purpose, case purpose. Okay, so he denied. He said that those statements I have made under pressure.
But at that time, he said, I have voluntarily given in 131.
Hey, this is
the
the
income
format
tax.
that everybody writes there. On being completely false, I deny the same. I never. Okay, then what else? What are the other answers?
Question
That
number 11 and its answer.
Question number 11.
Yes. And its answer.
He only says that carrying
everything
cash,
he has denied.
carrying cash is not an offense. He just said that. And then he has denied the statement made before the IT people. Where has he said that it was the money given by Crime?
I'm coming for that.
There is nothing. That the money was given by Crime, where has he said?
Question number 13.
30.
No, it is not with regard to that. Adhikari. I am not aware of any such thing as money was not paid to me by any bank.
49.
49. What is this answer? PW 46 has admitted that the loan amount has paid and cleared through one-time settlement. Okay. And anti-crime had paid the requisite amount long before filing of charge sheet. What does it mean? Amount is pending and is shown the business of prosecution?
Yes, the amount were paid earlier itself. Charge sheet was filed.
In what year? 2001.
2911.
It is 2001.
The
And in 97, DRT cases are there. NPA is there. And
were
2001.
paid prior to the filing of the charge sheet itself.
So before 2021, he paid
2011.
11. Charge sheet was submitted 2011.
Charge sheet was submitted in 29/11/2001.
2001. So
That has no
Prior to
relevance
the
with this
filing
case.
of the charge sheet itself, amounts are
So
paid.
that has no relevance with this.
Question
After
what amount?
investigation,
What amount?
My lord,
What amount was
the
paid?
loan amount, my lord, the NPA amount.
The Crime had paid that.
Yes, he had paid it even prior to the
Okay.
filing of the charge sheet. The accused is explaining that Kirmi is not coming to give false evidence in this case, only to save me. He has already paid that money. It was a bona fide transaction,
So 2001, he had cleared that amount.
clear.
And so,
2001, he has cleared that amount.
no, it doesn't matter.
Our cause of action is in the 97.
Ah,
How
that
it
I'm
has a
not saying.
relevance?
Don't get agitated. What I'm just clearing the fact. It's okay. 97, he was,
Yes, yes.
his one of the account was an NPA.
NP.
But he has other accounts, SBI accounts, two in numbers. One is,
I'm coming, how many accounts are NPA?
then what are the other answers? No, I wanted the answer to the question that Crime has paid that amount for purchasing diamonds. Where is that? So that he doesn't change his stand.
Question number 85, my lord, at page 238.
85.
Question number 85 at page 238.
Acha, in his defense.
Yes.
It is all in his defense. It is all in his defense, your lordship. Okay. That is, I gave a proper valid explanation to IO for this.
Acha, okay, Ms. Kumari, we stop here because I have some leftover matters also. So when can you again do it? You suggest a date.
As per the
What I'm suggesting you is this, you prepare a written argument, then you start arguing. Because I can then.
These are the only thing we have to, I have come to the DW. So in DW, we have to go by one question. So that I will mark it out in my argument.
You prepare it in the weekend
And now the bank official's statement is there who will depose that this account has become NPA. And
That's a subtle position, it has become NPA.
It is a matter of record also. It is a matter
No
of
one,
record.
he is not disputing, it's an NPA. But what he is saying is he has money from his business and all. But you are saying that his business was not good during that
Not
time.
good. And okay, he has the money, but he has to show the return. He is exempted from paying the tax, but he has to file the return. So that he was a solvent at that point of time, 97.
Okay.
That he
So
could
you
able
prepare
to,
the written argument and you come back next week then. I'll remember.
as you're not saying.
Next week, Tuesday.
Next week.
Today is Tuesday, next Tuesday. Hearing remain inconclusive. List again on
Next Tuesday means
9th,
9th.
9th of June. 9th of June.
Lighter note, I had a noted economist saying, if you want to be a billionaire, first become an NPA.
No, acha.
No, that is not
Is it?
applicable here. There are number of saying, your lordship.
And I also
This
take
will
objection
happen.
to my learned friend saying, pay the loan first, then buy the wife's jewelry. I hope my learned friend gives that advice to my family also.
You make advisor then.
It will always.
Again, I will have
I'm
to
not
distinguish
Kumar.
the judgment, your lordship. It is a big voluminous judgment. Each and
You make,
given by them.
yes, yes. If
How
you
it
want
is
to
relevant,
differentiate
how
it,
it is not relevant, I will have to
if
satisfy
you want to
myself.
differentiate it, make it in the, put it in your
I
written
have
argument.
already written here in every page why it is not relevant.
Hmm.
In every, I have already marked in every page. And I will mark there if your lordship will permit
Hmm.
in the page.
Yes.
First page, at least one has to be flat.
Mhm. Okay.
Then it would be easier. Khali first page to kore dile.
Okay, Mr. Nance.
I'm grateful. I apologize for interrupting.
No, no,
My
not at all.
punishment, I apologize.
Actually, I wanted to get clear.
Only for clarity.
Yes, only for clarity. But it had stopped her flow.
Yes, and I'm extremely, I am also apologizing if I agitated and I said something.
Ah, yes. Next Tuesday, you please finish it, huh? I'll
Yes,
reserve it.
definitely. I want to finish today itself.
But then, yes, time is short.
I want to finish today itself. I
You
also
prepared
don't
a
want
written
to
argument?
keep it hanging because it is also giving us trouble and time consuming.
Yes, this
Every
is
time I have to go through.
You keep the written argument ready by
And I'm
Tuesday.
extremely
Okay,
sorry
Mr.
if I
Kamal?
said anything.
No, no.
You-
Gratefully obliged.
Yes. Mr. P.K. Roy Chaudhary, your matter was there. No, you can do it. I'm sitting here. Yes. 7 first, Nikki. Mr. J.I. Bormia had come twice, so I'll just take up and then after.
Better come on 11.
On 11.
11.
On the prayer made by Mr. P.K. Roy Chaudhary, learned senior counsel assisted by R. Chaudhary.
Look.
Yes, I remember your name. I forgot. R. Roy, Rakhita Roy. List this matter on when? 11th. 11th of, matlab day of, oh, next week, 11th of June. Yes, Mr. Bormia?
As the case, my lord, lordship is aware, my lord, and while we during the midterm,
Hmm.
and I have taken out the notification, my lord.
Hmm.
It says, my lord, particularly lordship, in respect of the BTC area, man.
Hmm.
In respect of BTC area, my lord.
Hmm.
In the sixth schedule area, following order of the High Court dated so and so Borderland Territorial Council, district so and so territorial council will constitute its own district level committee, excluding the deputy commissioner and superintendent of police, but with the competent officers equivalent rank and control thereof the council, the district level committee will examine each proposal. Meaning thereby, my lord, all the job has to be done by the district level committee, my lord.
This is for what?
Yes, my lord. This is the compassionate appointment.
Compassionate appointment, yes. Also, you said that district DLC has recommended, SLC has rejected.
Rejected.
On the ground that number of years have elapsed.
Numbers of years have been in.
Acha, we wanted assistance from some advocate from the other side.
Yes, Lord, SLC.
Who?
M. Bhattacharjee appearing.
Oh, yes, M. Bhattacharjee. She was here.
She was here, just outside.
Just call her, please. Yes. So, what do you wanted to show, Mr. Bormia?
Lordship, that
In the sixth schedule area.
notification, my lord, though I have annexed in other case, particularly BTC area, my lord, the flag mark is the applicable.
Acha, in the sixth schedule area, following the order of the High Court dated in Borderland Territory versus so-and-so, the district and territorial council will constitute its own district level committee. District level committee excluding
Including only two persons, deputy commissioner and
superintendent of police, but with the competent officers of equivalent rank, and the district level committee will examine each of the proposals in light of the conditions laid
they have to
and
examine.
parameters laid down by the Honorable High Court, and after thorough examination shall forward the same with their recommendations to the concerned department, to the concerning department, territorial council for the. So SLC will not come.
SLC cannot go for examination, my lord, as it has.
No, what they said that DLC will consider.
Yes.
And will forward the same with their recommendation to the concerning department of district territorial council for due consideration.
Right.
So state level scrutiny committee will not come.
My lord, yeah, my lord, the scrutiny committee has, my lord, state level has.
So after consideration, the council will send the proposal to state level committee
last
for approval. But from DLC, it will go to the committee, to the council.
My lord,
Right.
yes.
So
Yeah.
here it did not go to the council. Ms. Bhattacharjee, you have some instruction in this matter.
Lordship, I indicated, but I have
Not yet received any instruction, Lordship.
Acha. Instructions for what?
Instruction, Lordship, if your Lordship go through the
No, here it is a simple case that DLC has recommended, but SLC has not.
yes, essentially recommendation is one thing and consideration is another thing. Direction of the Honorable Court was considered. It is
No,
not.
what is this matter? This is
SLC has considered.
Where?
Considered and recommended.
Lordship,
Page
kindly
40.
page 40.
Page 40, operative part of the judgment. Accordingly, this court is of the view that interest of justice will be served if the present petition is closed with the direction to the authorities, more particularly the DLC, to consider the case of the
Exactly,
petitioner in terms of office memorandum, which I have shown already.
Oh, this is the one. Okay.
And pass appropriate order thereon and exercise shall be carried out.
Okay.
without
So the
any-
DLC should consider. This is
Consider.
what.
So consideration is
And
there.
DLC considered and recommended.
Commanded.
It depends, Lordship. It depends. It doesn't mean that the consideration by the DLC has to be followed by the SLC.
No, this is not.
Yes.
Not required. Nobody is saying that.
And Lordship, kindly consider the date of death also. I'm not on that.
Yes, date of death was
Date of death
21.
is 2001.
2001.
Lordship. That's what I'm
2001.
saying.
And he made his application in 2002.
Okay, Lordship, 2002. But in between 2002 to 2016, what is his conduct? Where is all this? Where all these things are there, Lordship?
It is
How
said that
he
he
has
had filed
conducted
cases.
himself.
File cases.
Where he has shown his hardship.
It is there,
Anywhere in the application, Lordship.
Mm.
Anywhere in the application. That due to
Petitioner
this,
itself
that's
is a-
26 years, he or she is unable to survive.
No, see, survival is on the Lord. Survive, everybody will survive.
Lordship, that's
Everybody will survive.
That's what, Lordship. And Lordship.
Lord gives
kindly-
us food, not
Yes.
me.
Lordship, then
So this is what I'm on is SLC has rejected only on the ground of delay. But see, he has made
page
application in
63,
2002.
kindly, I'm taking Lordship to put the specific page number. Page 63.
63.
The last DLC.
SLC.
Yeah, sorry, SLC.
And he has placed a
Yes.
notification which
Vijay Deka, yes. The
no,
SLC
Miss
had-
Bhattacharya, he has
Yes.
placed a notification where it is said from DLC it will go to some council and thereafter
This
SLC.
is the, no. In BTC, as far as my concept, Lordship, their DLC, Deputy Commissioner, District Commissioner's role is very limited. This is done by the Principal Secretary. So here, the district committee, that means the DLC, what in other districts happens, this is little different in BTC law. So these things are done by the principal secretary and this is forwarded to the SLC for appropriate these things, Lordship. So accordingly, this has been taken. And Lordship, page 63. Decision of the state level committee is properly stated there, Lordship. There is not that there is no such ground. The SLC went through the order dated 9/8/2023 passed by the Honorable High Court in WPC number so-and-so, wherein the DLC has been directed to consider the case of the petitioner for appointment on compassionate ground in terms of OM dated 1/6/2015. The DLC in its meeting held on 29/2023 recommended the application of Sri Vijay Dekka to be placed before the SLC. The SLC noted that the government employee had expired in 15/2/2001. That is more than 23 years ago. The objective of compassionate appointment is to provide the bereaved family with immediate financial assistance to cope up with the situation. It is an accepted norm that in case several years have passed after the death of a government employee, it would appear on the face of it that the family has managed to support itself all these years and has some means of subsistence. And in such case, the compassionate appointment are not ordinarily to be given. In the instant case, the DLC has not recorded any ground for recommendation and in particular has not made up a case to justify requirement of compassionate appointment after over 23 years of the death of the government employee.
Yes, we have gone through this.
So this is this, even in 2015, Lordship.
But Mr.
2015
Barbuya,
when
before the SLC gives its report, you have shown me here that it has to be placed before the council.
It is a
Oh, yes,
notification.
cannot be, Lordship.
It
SLC
is the
super
notification.
author-
No,
super-
SLC will come after the council.
After the council.
That is what I'm saying. But
Yes.
from the DLC, it has to go to the council. DLC, it has come to the SLC.
SLC, my lord.
Lordship, what I have said, the DLC is done by the council itself.
But see the notification here.
Notification is different, but the BTC.
Lordship.
The district and territorial council will constitute its own district level committee, excluding DC and SP,
Yes.
but with competent officers of equivalent rank. The district level committee will examine each of the proposal in the light of the OM and parameters, and after thorough examination shall forward the same with their recommendation to the concerned departments of the district
Departments.
or territorial council for due consideration. After consideration, the council will send the proposal to the state level committee for approval. But here the procedure is wrong.
DLC, my lord.
Wrong, Lordship. Please come to the page number 42, Lordship.
42.
is the minutes of the meeting, district level selection committee, held on 23rd. BTC
Yes, 42,
secretary,
yes.
District level committee, man.
This is district level committee.
District level committee, Lordship. And so for the BTC, Lordship, this is the transferred district deputy commissioner power has been transferred to the BTC, it's including all district, one committee. This is the district level committee, Lordship. There is.
This is district level committee and district
Yes,
level committee.
Including all district. Lordship.
Yes, Lordship, the OM,
Sure.
OM dated 1/6/2015, the clause 8, Lordship. This is clear, Lordship. In the 6th schedule area. following the-
Accordingly.
Constitution.
District level selection committee done, they are recommended to the state level committee.
Whether I'm understanding it wrongly or what, I'm not able to get it.
Lordship is correct otherwise.
No, he is answering it wrong,
No, but-
differently.
I'll just let
Why don't you see the recommendation, the memo again?
memo tate আছে তো চাই লোৱা এইটো নহয় দিয়া
Forward the same with their recommendation. DLC will send a recommendation to the concerning departments of the district or territorial council, not Boroland Territorial Council. It is to departments of the district.
Lordship is having this 1/6/2015 OM.
Hmm.
Lordship may kindly go through this para 8, Lordship.
Para 8 only I'm reading.
Yes.
এইটোতে কৈছে না কেছ লয়
It has to be placed before the council.
No, no, Ruba.
8 নম্বৰ 9 আৰু 9 আৰু তাত
Lordship, please.
নম্বৰ নাম
As per this.
এইটো নহয় তাৰে পাঁচ
Yes, Lordship. First, they will, that means the concerned department.
Concerned
Department, they, because this is what? This is regarding if suppose, here it is the agriculture department. Suppose the posts are not there in the agriculture department, the
can be
authority, they can,
Post
call
it
for
somewhere
the-
else.
That means post in other departments, Lordship.
Accordingly.
So if it is available, then only with this, they can recommend, Lordship. Before the recommendation,
over
they
and
have
above, my
to
lord,
get to,
SLC's
So that actually was not done. Now the DLC's recommendation was not placed before the respective district council.
it is before that, that has to be done.
After that, it will go to SLC.
After that, it goes to SLC.
Whatever it is, SLC has also rejected on the ground that so many years, but that cannot be a valid ground.
Lordship, I may be.
It's not the fault
admit
of
one thing, Lordship.
8 নম্বৰটো পঢ়া
Accordingly followed, Lordship. However, Lordship, BTC is.
How is this
39
followed?
BTC
Show
is
me some
39
doc.
subject, Lordship, 39 subject. Date power given, Lordship. 39
It is in
subject.
respect of BTC only. You read 8, clause 8. Once again.
In the sixth schedule area, following the order of Honorable High Court dated 22nd March 2012, Borderland Territorial Council versus State of Assam versus WPC, so Lordship, the District and Territorial Council will constitute its own district level committee. This is the, please come to the page number.
No, that is okay. They had formed district level committee. Then after that you read.
Up, after the Lordship. Excluding the deputy commissioner and superintendent of police,
Yes.
but with that, this is excluding Lordship.
Go after that.
But with the competent officer of equivalent rank under the control of the council,
Go after that.
the district level committee will examine each of the proposal in the light of the condition laid down in this OM and the parameters laid down by the Honorable High Court in WBC, so and so Lordship.
Then you read.
And after thorough examination, shall forward the same with their recommendation to the concerning department.
Now, as Miss Bhattacharya had
District
said,
Public
so if it is agriculture department, it will be sent.
consideration. After consideration, the council will send the proposal of the state level committee.
Hmm.
Accordingly, Lordship, accordingly done. And here it is very clear.
Accordingly, how it is done. You're saying will not do, you have to show it in papers.
It's ours department, that is why Lordship.
Where is
Only
it
one
placed?
committee, departmentally done thereafter, that DLC recommended.
You are not understanding.
It is closed down, Lordship, accordingly done.
Are you're saying will not matter, show me from your documents.
Here in BTC, only one district level committee.
46 is the, my lord, page 46 of the DLC, my lord. It is relating to the agriculture department BTC. Name of the, applicant Vijay Deka, so and so, WPC, so and so, papers.
Vijay Deka is the petitioner.
Petitioner. His name has been recommended, my
Hmm.
lord. May I read, my lord? The applicant Vijay Deka, so and so, serving as a grade 4 in the office of the divisional officer.
He is the father.
Father, my father's place, my lord, I apply. Then service of the applicant Vijay Deka was applied for the compassionate appointment on 21/102. DLC meeting of BATC held on 12/15/16 under the chairmanship of the Fukon IS Principal Secretary, BTC cum Chairman. Compassionate ground could not be recommended. This prayer was the petition due to the lack of vacancy for the. Further, the Honorable High Court passed in WBC number, if the sufficient vacancies are not available in any particular office, accommodate the person to the other department for the compassionate appointment ground. At present, due to the availability of vacancy, DLC meeting on BTC recommended the application of Vijay Deka, son of so and so, to through welfare borderland territory department dispute for appointment to the compassionate ground against the sanctioned post. It seems, my lord, if last line is taken into account, my lord, Chandigarh SLC on the compassionate ground against the sanctioned.
So there was no vacancy in the agriculture department.
Yes,
So the court said that take him to some other department
yes, if it is.
if it is available. And then the vacancy were available where now? At present, due to availability of vacancies
Vacancy is there.
in the agriculture department.
Yes, in agriculture.
But
Now it-
this is under the 5% compassionate quota. This also has to be looked into, Lordship.
5% compassionate
Yes,
quota.
of the cadre strength, whether these are available or not.
Although
Any vacancies
available.
cannot.
That is not a
any
ground,
Vacancies cannot incur.
but that is not a ground for rejection by the SLC.
Lordship,
SLC has no power, my lord. So for the
Really?
selection is concerned. Selection is being done by
5%
the
has to
DLC.
be, has to be of the cadre strength. And this 5%, in no other, any vacant post cannot be considered for appointment under.
But these are
compassionate
not before any committee. Even DLC has not dealt with it, even
quota.
SLC has not.
Properly mentioned anything, and why they are choosing, that means about the petitioner to be considered for compassionate appointment. This has not been properly addressed here
It
while
is there, my lord.
forwarding.
By
it.
virtue of the High Court direction, my lord.
First of High Court direction, this can, there are so many cases, Lordship. If this is so, then why they didn't file any contempt case, Lordship, that this has not been
High
paid,
Court
Lordship?
has directed for consideration.
And only consideration means consideration doesn't mean appointment.
No, it doesn't mean.
So
Only
consideration is
consider.
considered, Lordship.
And it was considered. And DLC has recommended.
Recommended.
SLC also has considered, but it rejected.
But on what ground?
Yes, ground is rejected.
So from
Para
2002
Para
to
two. Para two it is
2023, what happened?
I filed 3 number of cases, including this one, man. One after another, because they are sometimes they are sick.
Where have you filed
Yes,
cases?
yes, I have an next, my lord.
Hmm.
I have a next. Lordship kindly, first order, Lordship will see. Page 29 is the first order, my lord. 2002 itself.
That was 2002.
2.
He had filed for compassionate appointment.
Consideration of his appointment. Then again, my lord.
What was the order in that petition, in that order? Again, consideration.
For consideration.
Consider the case of the petitioner, page 20.
We did, even a petition we have. We did consider the case of the appointment commission within a period of 3 months. Okay. So that was disposed of in
By-
2000?
Thereafter, my lord.
2002.
Yes, my lord. Thereafter, another writ petition, man.
Hmm.
Petition.
Then he communicated it to
23,
the,
Lordship. Then 23.
then he communicated to the authorities, right?
Yes, yes. All the thing I have done it, man. I was not sitting idle, my lord. All the ways I am hesitating like anything, my lord. I am a qualified boy. And I am in distress, man. So
Yes.
ultimately, my lord, the DLC recommended my case considering all the spec. That was, my lord, not considered. And
Acha, 3 cases you said. You had shown only 1 case. Then?
then, my lord, another order from the order, your lordship will see. DLC meeting of the IS principal.
Then directly after 20 years on 23, they have filed a case. If your lordship may kindly peruse this
An
one.
earlier order to attack.
No, this has been,
There is. Further, the honorable court passed order directing the consideration 13 also, with the president's answer. I got it, my lord, because I did the case. Chairmanship of the MKDAS and then committee taking this, Suchitra. Yes, sir.
Acha, 21, he was informed that there were no vacancies.
so here only one case has been referred.
So
659 to 2002. In
Hmm?
between, there is a 20 years gap, lordship. Lordship
What
may
is my
kindly.
wrong, my lord? What is my
No,
wrong?
but then see in page 38,
Yes,
they
page 30, page
okay.
38, I'm referring.
In terms of the said direction, a matter was processed and considered at different levels by different officers for last several years. And ultimately, by communication of 21, petitioner was informed that no vacancies were there.
Yes. It is their statement. It is their statement, not observation by the court.
And
is
this
their
one is for the second time, Mr. Bormia.
Yes.
This is for the...
So these 20 years, how they will describe lordship? Devabrata Tiwari, how they will overcome?
My lord, whether
How they will overcome?
SLC have-
Devabrata Tiwari says what?
This is the
This is for
prolonged.
the new case, my lord, not for the old case. This is up to 17 to be considered. 4th April 2007.
Show
That
me
has-
Devabrata case.
Lordship, kindly take it up tomorrow. I shall provide all the cases which has
Okay.
been decided by this honorable court. All the coordinate benches. I shall
Okay.
provide all the judgments. Then lordship will decide.
Miss M. Bhattacharya?
Lordship,
Learned-
can it be as a part heard, my lord? So
Yes, yes. part-
Tomorrow matter will
If
come up.
it does not reach, my lord.
No, it will reach. It's okay. Will you remind me? I'll see. She will also come prepared, so I'll take it up. Miss
I shall provide the judgments only.
M. Bhattacharya, learned additional senior government advocate, praised that the matter to be taken up tomorrow. That is
At
on
2 o'clock, man.
3rd of June.
At 2 o'clock, man.
Prayer is allowed. List this matter on, list this matter on 3rd of June.
At 2 o'clock, my lord, it will be convenient by the other matter.
As per lordship convenience. 2-3 days.
At 2 o'clock.
I shall use all the
Yes, yes, I'm
judgments of the coordinate bench lordship.
Division
Okay.
bench also. Petition to lord.
Then,
May I take back that petition?
oh, yes, yes. Yes. I did it.
But unfortunately,
Yes, 48. Yes, Mr. Ahmed.
It will take some time, but
What is this matter about?
matter, my lord, he was dismissed from service.
2017 matter. I don't want to get it adjourned. Please, let me know if you don't take much time. Be brief. Yes, you have something to say?
Lordship, we have received the records and your ladyship, if goes through the writ petitions, nothing is there in his writ petition.
Acha,
Only
okay.
the order of dismissal is there. So,
Okay, let him start.
yes.
Yes.
Lord, initially the petitioner was appointed as a constable
Mm.
and he was, my lord, dragged in criminal cases.
Uh-huh.
Criminal cases, my lord. 2 cases were against him, my lord. And in the trial proceeding, my lord, he was acquitted.
In both the cases, he was
He
acquitted.
was acquitted. Later on, my lord, I have.
Acquitted honorably or what?
My lord,
For lack of evidence, honorable acquittal or what? Or for benefit of doubt or something?
benefit of doubt.
Benefit of doubt. Then it is not honorable acquittal. Then?
Prosecution, my lord, did not prove the allegation against the petition.
But cases, acquittal is on benefit of doubt. Sure. Yeah. Then?
I have.
Then what about the
annexed-
proceedings?
Annexed both the judgment in my lord, additional affidavit. That is, my lord, I filed it on 28/2/2020.
This is, one judgment is 18/9/2018.
Yes,
Right. There are other accused persons along with you.
all were acquitted.
Hmm.
One is, my lord, 18/9/2018.
Hmm.
And another is, my lord, 14/11/2018.
Mm-mm.
In both the cases, the petitioner along with other accused, my lord, were acquitted. So, my lord,
View the accused deserves benefit of doubt. What about the other? Here also benefit of doubt.
yes,
Where is that benefit of doubt in the second case? Page 65.
yes, my lord. Yes, 65, my lord. Moreover, the number of contradiction and would see in the deposition of all the prosecution witnesses reveals upon the inquiry of the cases. Furthermore, where the informant accepted that he had lost the azahar after a week of the occurrence and stated no reason for such delay over Exhibit 1 and PW3 being the brother of PW1.
Okay, fine. Then what happened in the departmental proceeding?
And departmental proceeding, my lord, he was dismissed from the service.
Show cause notice was given, you submitted a reply, inquiry report given to you.
Everything has.
Then on what ground are you challenging?
My lord, so far the, my lord, major punishment is concerned, my lord.
Not proportionate.
Yes, ma'am.
Then
That's
what?
a very good ground.
Not proportionate with his, what is the offense?
Offense was, my lord, extortion.
Huh?
Extortion.
Extortion. He is a constable.
He was a constable.
And allegations were of extortion. Extortion from?
He demanded some money.
From?
Which is an admitted fact.
From others. From my lord, one person who was a driver.
Over the?
who was driver carrying some boots man.
Acha. No, you want to say the punishment is not commensurate. Any judgments on this? Proportionate?
Yeah.
Yes, what are the judgments?
Not one judgment, nor High Court, my lord. 2017 3 GLT.
What does it say?
I am referring them.
Yes, Mr. Bothakur, you are sitting for a matter. Whether it will be possible for me to take up? Which matter?
56, your lordship.
56.
If you lordship can fix it on 11th, your lordship. Some urgency is there. It is
Okay.
coming.
As prayed for by Mr. S. Bothakur, Learned Senior Counsel, assisted by Mr.
T. Bora.
T. Bora, Learned Counsel for the petitioner, list this matter on 11th of
11th of this
11th of this month.
It can be taken up at any
Okay, I'll take it up. Don't worry.
Lordship, I have a similar prayer for 58 was upgraded. But
Oh, upgraded.
but there's a paucity of time, your lordship, may take it up on 18th of June.
As prayed for by Mr. B. Bora, D. Bora, Learned Counsel for the petitioner, list this matter on 18th of June. Yes. Yes, Mr. Kolita.
I think was 55.
Huh. No, that took time, no? That criminal matter took time. That is how it didn't reach.
Criminal matter.
No, that criminal matter took time, so your matters did not reach. 55 is what, when do you want? On the prayer made by Mr. N.K. Kolita, Learned Counsel for the petitioner, list this matter on 16th of June.
I think 56 mal it has been fixed on 11. My presence
56.
may be recorded mal on.
Uh-huh.
My presence will be recorded on.
No, Mr. B. Gogoi, लिख दिया.
57.
57.
24.
24 matter. 17 matter I'm giving preference. So 24, okay, as prayed for by Mr. S. Bothakur, list this matter on
16
on 16th of June. 54 to लिख दिया. On the prayer made by Mr. P. B. Dewry, list this matter on 11th of June. Yes, Mr. Ahmed. Yes.
My lord, in my writ petition, my lord,
Hmm.
I have annexed the, my lord, appellate order.
Hmm.
That is at page, my lord, 23, my lord.
23.
Yes.
Yes. Hmm.
Nothing is there, no discussion is there, my lord.
This is before the appellate authority.
Three lines order, my lord, with reference to the above, the files and files.
Yes, I've seen. Hmm.
This is my.
After I consulted thoroughly, this is what, of course, not a speaking order,
Yes, my lord.
but thoroughly agree with the conclusion.
Yes, Honorable Supreme Court as well as the High Court emphasized that there should be discussion in appellate order.
And what about the, where is your impugn order? Show me that.
Impugn order at page, my lord. That is at page 11, my lord.
Hmm.
Although, my lord, this is a parallel proceeding, my lord. This is a parallel proceeding, my lord. The proceeding, my lord, the departmental proceeding, grossly, my lord, disappropriate.
Yes, of course, in the criminal proceeding, you were discharged, you were acquitted. Had it been an honorable acquittal, then it would have an impact on the disciplinary proceeding, but that is on benefit of doubt. So that is not an honorable acquittal. So that will not have an effect on the departmental proceeding. So departmental proceeding, of course, you can say that it is not commensurate. Dismissal order should not have been there. Some other punishment could have been given to him. Because there is a 1 year delay in filing the FIR by the complainant, right? But then it is said that he had what he has exhausted all his remedies, and then unable to get any justice, he complained. And those things are there, but show me those judgments. You wanted to show that the punishment is more harsh in respect of
My
the.
lord, the 2017 3GLT, my lord, I am referring, my lord.
Huh.
He-
But then there are other complaints also against him, right? And he was suspended with regard to that complaint. His duty was to remain present in police reserve, but he was not there in the police reserve. There were other complaints also against him.
These were set aside.
Hmm?
These were set aside.
By the criminal court.
Yes.
Criminal court.
Yes.
But then his dereliction was seen. He was not there in the police reserve.
Perhaps not true.
Acha, show me the judgment. There is no time. Give. What happened here? Paragraph?
Paragraph, my lord, 4, 5.
No, take me to the relevant paragraph.
Then, my lord, yes, 4, 5, 7, 13, 14, 15, and 16. In 2017 3GLT, may I read mine?
No, it's okay. Then 2010.
2010 to Supreme Court, USCC 3, my lord, paragraph 5, 6, 7, 8, 9, and 10.
Yes, what do you have to say, Miss?
Your Ladyship, my submission is that this writ petition is filed by the petitioner with full misrepresentation and suppression of material facts. My lord, the petitioner, he has not even obliquely stated in his writ petition about his participation in the entire departmental proceeding. He has not challenged the inquiry report. He has not challenged the departmental proceedings, which he is now claiming to be not proper. And after, my lord,
No,
in,
what I can see is here from the order, impugn order,
yes,
he could not produce any witness,
Ladyship,
documents, evidence to prove his witness. Otherwise, he had taken part.
he has taken part. First show cause notice was issued to him. He made a reply to that. And against that reply, inquiry proceedings were initiated against
He did not
him.
reply to the show cause, Mr. Ahmed.
Show cause, he made a reply. He made a reply. Second show cause notice was issued to him. Inquiry report was given to him. He made a representation against that inquiry report and being against the 1 year delay, Your Ladyship. The departmental proceeding order also states, also has rebutted his claim that after 1 year he has filed an FIR.
That is stated that he had
Yes.
Exhausted his wealth and
he
so.
exhausted his wealth. He's been extorted of his wealth for this period of 1 year. And after that, only he has come to this to file the FIR. And in this statement also, Jamal Ali, he has accepted, he has admitted to his being present in the.
Where is the reply to the second show cause notice?
It's
Is it
in the-
annexed, Mr. Ahmed? I'm asking you.
I could not, my lord, annex,
Nothing is there in the writ petition.
but in the record itself. The record itself.
Record is here.
This is 2017 matter, right?
But, what happened, my lord, earlier earlier says of advocate, my lord?
2017 matter, and then you were dismissed from service.
Yes, after this.
Now at this belated
I
stage.
engaged in this case.
Huh?
After.
Oh, it's okay.
I engaged.
But at this stage, you do one thing, you make a second representation before the authorities saying that your punishment was not in proportion since you are acquitted. Okay. I'll write the facts and then you make an application, right? Heard Mr. S.A. Ahmed, learned counsel for the petitioner, and Miss
You, Sharma.
U. Sharma, learned standing counsel for?
Government advocate.
Oh, learned government advocate. Representing respondent number 1 to 5. Oh, no, it's not required. Regarding government advocate. By this petition filed under
1 to
Article.
4.
Huh?
1 to 4 years.
By this petition filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside of the order dated 24/12/2015 passed against the petitioner. 24/12/2015, by which the petitioner was dismissed from his service. Was what? Removed or dismissed or what?
Dismissed.
Was dismissed from his service. The petitioner has also prayed for a writ in the nature of mandamus, directing the respondents to reinstate the petitioner in the service forthwith and regularize his by regularizing his services. To reinstate the petitioner in his service and regularize his service as well. The case of the petitioner is that he was appointed to the post of constable in the year 2010.
2010.
In the year 2010 and was posted in the said capacity at Sibsagar DEF. DEF is?
District Executive Force.
District Executive Force. Huh? And that since then, he has been working as a constable. However, where is show cause? Show cause also you have not. And next, show cause?
No.
Why?
It's
It's okay. That thereafter, the petitioner. No. Thereafter, a case was registered against the petitioner as Simoliguri PS case number 30 of 2014 under section 389/387/506/34 of the IPC. The said case was registered on the basis of a complaint made by one Jainuddin Ahmed on 14/3/2014 stating inter alia that he, that is the complainant, was an employee of ONGC Private Limited and while he was on his way to Sibsagar from Simoluguri, he saw a vehicle and requested the driver of the said vehicle to take him to Sibsagar town and while he was coming in the said vehicle, he got senseless and he regained his sense in a house and found two men who had pointed him a pistol and demanded rupees 1 lakh from him by threatening him that they would publish his naked photograph with a woman. Full stop. Due to the threat given, the complainant gave rupees 1 lakh and subsequently also he gave more money. And then even more money was demanded from him. On the basis of the said FIR, the criminal case was registered. It is stated by the learned counsel for the petitioner that, no, there was another case also, no?
Yeah.
What is the second case?
Second case is my lord as case.
Second case was also similar.
58. This 58.
Apart from the aforesaid case, another case was also registered against the petitioner and others. Which was registered as Sibsagar PS case number 413 of 2012 under section 294 and 387 read with section 34 of the IPC. The learned counsel for the petitioner submits that the petitioner who was implicated in the said two cases were acquitted, was acquitted by the criminal court by judgment and order dated 18/9/2018 and 14/11/2018. It is seen that the first case was disposed of by the said judgment and the petitioner was acquitted along with others on benefit of doubt. And the second case was also disposed of on the ground that no incriminating material is brought against the accused persons. And as such, the petitioner, along with others, were acquitted. Para. On the other hand, the petitioner was served with a show cause notice on the charges of serious misconduct, comma, dereliction of duty, and moral turpitude. Full stop. And thereafter, oh no, full stop now. And thereafter, a second show cause notice was issued against the petitioner. Full stop. It is stated that the petitioner filed his reply to the second show cause notice, wherein he had raised the plea that the complainant had complained about the fact, about the alleged fact, 1 year later from the date of occurrence. Full stop. He had also taken other grounds on his in his defense. The petitioner was also put under suspension on 9/7/2012 based on another complaint. Full stop. The inquiry was conducted against the petitioner, where he had participated and in conclusion thereof, the Superintendent of Police, Sibsagar, Assam, passed the order dated 14/12/2015, by which it was ordered that a police officer must not resort, by which it was observed, Yana, order none, by which it was observed that a police officer must not resort to such acts which may encourage or abet antisocial elements and criminals directly and indirectly. Full stop. It was also stated that the petitioner had admitted his presence at the place of occurrence to help the criminals when a crime was being committed and involved. It is further stated that if a police officer sees any crime being committed, he should immediately inform the police personnel about the crime and get the criminals apprehended. But the petitioner, instead of informing about the crime, demanded money from the victim, which was a serious misconduct on the part of the petitioner. During the inquiry proceeding, statement of witnesses were recorded, and it was found that the petitioner had abated a gang of antisocials in the crime. And further that the petitioner could not produce any witness, documents, or evidence to prove his innocence. On the said grounds, full stop, on the said grounds, the petitioner was dismissed from his service. The learned counsel for the petitioner submits that the petitioner being acquitted in the criminal cases should not have been punished in the departmental proceeding. He also submitted that the petitioner had filed an appeal before the appellate authority, that is the Deputy Inspector General of Police, and the appellate authority, without any discussion on the issue, had agreed with the conclusion of the disciplinary authority and upheld the order of the Superintendent of Police Sibsagar. Miss U. Sharma, learned standing counsel submits.
Government advocate.
Government advocate submits that the petitioner has himself admitted his guilt before the inquiry officer, and that the punishment inflicted upon him is proportionate to the misconduct he did. Para. It is noticed that in the criminal cases which are on the same facts, right? Same facts, which are on the same facts and offense to which the petitioner was subjected to in the disciplinary proceeding, ended in acquittal of the petitioner along with others. Full stop. It is also reflected that there was no incriminating material, there were no incriminating materials found against the petitioner and others with regard to the said offenses. But it is also seen that the petitioner was not honorably acquitted in the said cases. Full stop. In the said criminal cases, the petitioner and others were given the benefit of doubt and was acquitted and were acquitted.
One case, my lord, beneficial. Another case, no incriminable material found against.
Yes, I've said that one case and second case, but this one case will matter if it is not honorable acquittal. This is what. At the same time, the dismissal order of the petitioner pursuant to the departmental proceeding also seems to be harsh. It is stated in the impugned order that petitioner had abated the crime committed by others and that it is also in the evidence of a witness that he had actively abated a gang of antisocials in the commission of the crime. In view of the said findings of the inquiry officer, said findings of the disciplinary authority, as well as the acquittal order by the criminal court, this court directs the petitioner to submit a representation before the Superintendent of Police, before the concerned authority / Superintendent of Police Sibsagar for considering his case and to impose a lesser punishment which is commensurate with the offense as mentioned in the impugned order. But then this order has attained the finality, right? This is also gone. So what? We'll have to set aside this order.
Lordship, it is
Only
an
dismissal order will be set aside.
The dismissal order will be set aside, then my lord, appellate order will also
Also go.
automatically be set aside. But your ladyship may give him one chance to make an appeal so that the appellate order is written properly, you know, with giving proper reasons from that stage, you know, because it is an admitted fact and my lord knows well that admitted fact need not be proved. He has admitted to taking
appellate order is
extorting
also-
money, my lord. He is a police official and it is highly unbecoming of a police official to even take 100 rupees also, my lord.
Yes, this is there.
But he's
But
already
what,
taken
let the order of superintendent remain, you appeal before the appellate authority.
Unless the dismissal order is set aside.
If the dismissal order is set aside, then you will have to go against before the superintendent of police. We will, without setting aside the dismissal order, you go before the appellate
appeal,
authority.
yes, my lord. Because that appellate order admittedly is, my lord, without any reason or rhyme. From that stage, we can consider his case. But my lord, dismissal order may not be because
Okay, that is more proper. Okay, এটা কাম কৰা হেৰি লিখা further এইটো court deems it fit তাৰ আগত দিয়া সেইখিনি থাকক তাৰ আগত এটা লাইন দিয়াচোন further এইখিনি থাকক further it is also seen in the appellate authority's order that although it is written therein that a detailed discussion, what detail, no, is stated therein that consultation was done and after the same, conclusion of the superintendent of police was upheld. But the same is not, if the same does not seem to be a reasoned and detailed order. As such, hetu ahi jabo tarpisot, in last line to fit. This court deems it fit that the petitioner would submit a representation, submit an appeal, would prefer an appeal before the Office of the Deputy Inspector General of Police, Eastern Range, Assam, Jorhat. Who would consider the case of the petitioner in the light of the statements made above, in the light of the observations made above. Full stop. As such, the order dated 22nd of June 2016, passed by the appellate authority, is set aside. Petition is disposed of. You file an appeal, they will consider.
The representation, my lord, verbally disposed of within a period of.
No, this is not representation. You have to file an appeal.
Yes, ma'am.
Whatever is provided in the rules, appeal to be disposed of, something is there. That appeal, further, it is directed that the appeal may be disposed of within a reasonable period of time by the appellate authority. Okay?
highly obliged.
Petition is disposed of. Aru asa ni? Okay. 53. Some other day. On the request made by the London councils for the parties, list this matter on
Next week, madam.
List this matter on 9th of June. Out tonight? Well, out.